Or yes or no? You are opposing adjournment or agreeing for adjournment? Nothing. Let us see. ಅವ್ರನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಬನ್ನಿ, ನಾನು ಬೇರೆಯವ್ರು ಮುಗಿಸ್ತೀನಿ. ಅವ್ರು ಒಪ್ತಾ ಇಲ್ವಲ್ಲ? ಇನ್ಫಾರ್ಮ್ ಅಲ್ಲ, ಅವ್ರು ಒಪ್ಕೋಬೇಕು. ಇನ್ಫಾರ್ಮ್ ಅವ್ರೇನು ಬಂದು ಅಪೋಸ್ ಮಾಡ್ರೆ ತಗೊಳ್ತಾರೆ. 36. Well, next Wednesday, entry amount to be extended to 1, 1 to 7, list number 2. Next Monday. 29th. B group. Next to that. You can't fix the date. You are saying yes. Either you oppose adjournment or agree for an adjournment. Let us wait.
Your Lordships, kindly, my lords.
Yes.
My lord, serial number 49, my lords. I'm not feeling well today, my lords. Kindly have it next week, my lords.
Next Wednesday. Have you informed the other side?
My lords, I inform, my lords.
Number 1 for order. Serial number 1. Submission to say.
Pass sir.
Number 2.
Not con.
Senior counsel directed the government to secure the land grant register, amendment of cost rating and
produce the original order of grant set to have been made in favor of fourth respondent. Sikta. I don't want to summon the officers. You are forcing me to summon them. Markondilva. There's already an order. We want a second order. Lieutenant Counsel for the fourth respondent in WP number so and so submits that he would make an attempt to secure and produce the original order of grant said to have been made in favor of the fourth respondent. Meanwhile, fourth respondent. Shall I say that you can't secure the grant? The Lieutenant Counsel for the fourth respondent submits that he is unable to produce the original order of grant, but nevertheless a certified copy of the grant is produced. In the light of the above, the Lieutenant AGA is directed to secure the original order of grant made in favor of the fourth respondent on or before next Wednesday. It is made clear that if records are not produced, the Deputy Commissioner, Bangalore South, Bangalore, shall be personally present before this court. List on. If he does not secure the records, you should be here. Weeks time. By then, counsel for petitions counsel is to amend the cost rate and also file an amended cost rate. Do what you do. The 2013 madam, I'm not intending to grant 2 weeks. I'll grant you 1 week, sir. Secure instructions by them. When did he die? Next Wednesday. ಅದು 2 weeks ಕೊಟ್ಟರೆ 2 weeks ಆಗುತ್ತೆ, ಒಂದೊಂದು ವಾರ ಬಿಟ್ಟು ಬರಲಿಲ್ಲ. No, I will ensure that they get it by next week.
Appearing for petitioner in this case, my lord. My lord, in the last date only the notice to the applicants has been served, my lord. I represent petitioner number 527.
ಅದ್ರ ಮೇಲೆ ಐ ಹಾಕೊಂಡಿದ್ರೆ ಐ ಎಲ್
Whom do you appear for?
My lord, I appear for petitioner number 527, my lord.
Eva.
The memo was filed, withdrawn in the petition. The memo is signed by all the petitioners. And on the basis of the memo, the expedition is disposed of. Now it appears petitioners 5, 6 and 7 are filed as recorded application. Saying that they are not filing. That is the application now. It is now before.
You appear for petitions 5, 6 and 7?
Yes, my lord.
There was earlier
Lord, there are totally two families. Petitioner number 125 belong to one family and 527 belong to
You
another.
take notice for P1 to P4. Varadarajan, you take notice for P1 to P4 because permission. Then it will be never ending. What is the ground stated for recalling?
Yeah, I'm not saying anymore.
Allegation is against you that they had not instructed you.
Yes, my lord. The petitioner number 1 has instructed, my lord. If they are not willing, let them withdraw their petition, my lord. But we are petitioners number 527. There is different survey number and different orders.
Have you stated that you have not signed the memo?
Yes,
Or
my
the
lord. I have
signatures are
stated.
forged?
Yes, my lord. I have
Which
given
paragraph?
police. My lord, paragraph number 6, my lord. Even I went and inquired with the advocate also, my lord. They
You have
told that
not. You have not said that. You have not said that the signature found in the memo is forged. You only said that you did not instruct them to file the memo.
yes, my lord.
Para 6.
That signature does not belong to us also, my lord. We have given police
You have not
complaint.
said so.
Please,
You have
my lord.
not said so in the affidavit.
Yes, please, my lord.
Then, if you don't deny your signature here, it will have to be accepted.
My lord, we have not met the council at all. We have not informed. The petitioner number
I
1
don't
has.
know in the affidavit. I'm going by your affidavit. Please read para 6 of your affidavit. the signatures tally. I will refer this to forensics. If it is found that it is your signature,
Yes, my lord. Please, my
per
lord.
person,
Definitely, my lord.
but where have you denied your signature in the affidavit?
My lord. My
Where
lord,
have you said?
I will file affidavit regarding that also, my lord.
No,
We
no,
have
I will
given
not
police
permit you to file
complaint.
a better. This is not condition of delay for you to file a better affidavit. You should have said that you have specifically should have narrated that you had not sent the memo. It is not a blank memo. Your signatures are found on page 2.
My lord, that is not my signatures, my lord. Already I have given police
You have
complaint
not said
against
so,
me.
Mr. Counsel, in the affidavit. You have not said so.
I
Show me
have-
one government in the affidavit.
I will file my fresh affidavit, my lord, in this
No,
regard.
I will not permit you to file an affidavit after I show you that there's a lack of government.
Lord, without the consent of the petitioner number 5 to
I
7.
understand, but you should have been careful when you filed the memo. You're making allegation against the council.
Yes, my lord, definitely. We have met that counsel, my lord. He himself told that your client has not informed me. That day we have met the counsel, Vardarajan sir, my lord. He told only petitioner number 1 came to my office. He gave this memo. Your petitioner number 5 to 7 did not come to my office, signed my memo. He himself told to me, my lord. I was surprising to know that
All right.
he only called the petitioner number 1 and asked about the said incident, my lord. In my
For
presence,
how many years have you been practicing?
10 years, my lord.
If you expect all the clients to come and send the wakalat before you,
My lord, as
and the
per my
wakalat is given to you.
My lord, as per my instructions, petitioner number 5 and 7 never signed the joint memo, and they have not
Go
given
take
consent.
Go take action against the council and do whatever you want to do. I will not permit you to withdraw the writ petition. With these kind of governments, I will not permit you.
My lord, we have filed the police complaint also against petitioner number
All
1.
right, fine. Then
He has,
they will take action.
he has done this mischief, my lord. For all the petitioners, the present council was appearing, my lord. Without the consent of petitioner number
I'm
5
telling
to
you, I'm
7.
repeatedly warning you.
Please, my lord.
Repeatedly warning you. You do not know anything about the happenings between the council and the clients. Don't step into the shoes of the client if you don't know the complete facts.
My lord, we personally went
Then
and met
you,
the
if you are guilty of wrong pleading. You do not even state in your affidavit, and you have drafted this affidavit. Where have you said that the signatures are forged? You want us to hold a roving inquiry because your clients are agreed?
My lord, I may be permitted to file fresh affidavit, my lord, regarding this. I will produce the police complaints also given against the
No, I will
petitioner.
not permit you. You cannot make such a sweeping statement and get away with it. An application, the writ petition was dismissed as withdrawn on 4th of September 2020. The said order was passed on the basis of a memo dated 2/9/2020. This memo contained the signatures of all the 7 petitioners. The signatures of petitioners 4 to 7, Alva, 4 to 7 is found on page 2 of the memo. Thereafter, on 26th of November 2020, an application is filed to recall this order. In the affidavit in support of the application, it is stated as follows, para 6. Para 6(2). As could be seen from the above paragraphs, there is no assertion or a specific government that the signatures found on the memo for withdrawal is not the signatures of petitioners 4 to 7. In fact, in para 6, it is stated that the applicants did not instruct the learned counsel to file the memo to withdraw the writ petitions. This indicates that they had signed the memo, but had not instructed the council to file the said memo. In my view, having regard to the averments made in the affidavit, the petitioners are not entitled to seek for recalling of the order dated 4th of September 2022. The application is therefore dismissed. Next part. Learned counsel for the petitioner, however, contends that he has initiated proceedings regarding the filing of the memo. It is made clear that this order will not come in the way of such proceedings.
Number 5, the not PC.
Who is R5? What is the matter? Who has been implemented? Who has been implemented? It has been rejected.
Deciding the straight away proceeds to pass the order.
Have you challenged that order?
That order is
You should have gone to the DC, isn't it? AC or DC?
special.
In what way are you interested in the land?
By virtue of the obtained to my father.
No, the kata was changed on what basis? Which led to the filing of the appeal to the Assistant Commissioner. Which is the original order?
My lord, they are approached the Assistant Commissioner
Challenging which order?
for seeking grant of occupancy.
The kata and the he is passed out in favor of the applicant or against the. And you are?
I am the increasing applicant.
Now, what is your claim over the land?
For the land while on the basis my father acquired the land. Produce the same. My main reason is my the increasing without deciding the
But you did not make any application.
I tried increasing.
When did you purchase it?
My father purchased in the year 1965.
When is the order passed?
Order is, my lord, what has happened, my lord?
Is it the fact that suits had been filed against you had filed, the father had filed suits and you withdrew the suits?
No, initially suit was filed by myself and my brother, seeking permanent.
In that suit, it was informed to you that there is an order of the special DC in their favor.
My lord, the specialty order was filed. Initially, the occupancy rate was granted in favor of the respondent in the year 1987. Subsequently, this honorable court set aside.
So you were informed about the occupancy that's granted in the year 87.
I was there on informed.
In the suit, it was informed.
Suit it was not.
Why did you not say that? Why did you not inform them? ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕಲ್ಲ ಈಗ
My lord, initially the occupancy rate was granted. Subsequently, this honorable court demanded that when the matter was pending, I preferred pleading application before the specialty. Then ownership by virtue of assembly obtained by my father. According to the while deciding the matter, my lord, without deciding the pleading application, the special
when you made the application for pleading,
including application was never decided. The matter was disposed of on merits, granting occupancy rates in favor of the third respondent.
take steps against R5. R3 na R5. It is stated that the fifth respondent, right on. How is she related to? Are they related to R3 and R4? All of them are LRs of somebody.
Yes, yes.
Applicant yaru? Order ಆಗಿರೋದು ಯಾರ ಪರ?
In favor of the respondent. Yes, yes.
In what way are they related then? Where is the order of the DC?
Order, this is
50.
57.
Then Srinivas Reddy was the applicant. You are the LR of the Srinivas Reddy. Then the LRs are already represented. Why do you want? No, but the occupancy rights is granted only in favor of Ashok Kumar. But it is not granted to Vimlamma. Vimlamma has not challenged the order. Vimlamma, if she has not challenged this order, conferring occupancy it's only in favor of our brother Ashok Kumar, then what does she have to do with this? I will say it's not necessary. Why should we unnecessarily waste time on her? She has accepted this order. It is seen from the order of the Deputy Commissioner that the original applicant was one Srinivas Reddy, and on his death, his son Ashok Kumar and two daughters, P.S. Jayalakshmi and P.S. Vimlamma, were brought on record as the LRs. The Deputy Commissioner, by the impugned order, has registered only the son of the original applicant, that is A. Ashok Kumar, as an occupant. He has not registered the other LRs, that is P.S. Jayalakshmi and P.S. Vimlamma, as the LRs. The daughters have also not challenged the registration of their brother as the occupant. It is therefore clear that the daughters of P. Srinivas Reddy, that is P.S. Jayalakshmi and P.S. Vimlamma, have accepted the order in favor of their brother, and they have no interest in the subject matter of this writ petition. Therefore, even though P.S. Vimla, the external respondent, the fifth respondent, is
Therefore, even though P.S. Vimla, the respondent.
they've accepted the event. Perhaps it is also seen that the claim of these two sisters for registration as an occupant was specifically considered by the Deputy Commissioner, and he has also rejected their claim. This rejection of the claim has not been challenged by the daughters. Number you are filing, you had filed wakalat to them. You should R4 Garrett. R5 is served and under president. Why should I waste my time so much?
This rejection of the claim has not been challenged by the daughters.
It is also noticed that the fifth respondent, Vimlamma, though served, has chosen to remain unrepresented. In a case where a respondent has been served and remains unrepresented, on her subsequent death, it will be not necessary to bring her in-laws on record in view of 22 rule. Therefore, no steps need be taken against R5. R2, Aaron?
R2 is represented. I've served the copy on the government.
When a AG accepts notice for R2. B group rule issue ಆಗಿದೆಯಾ? Post for B group. Find out if you have that number. I'll have that question also. Post in B group for 2 weeks. Date 2 weeks. Who's R1? when AG accepts notice for R1. Interim order is extended to the next date. Finally, 1 week.
Sharing for petitioner, my lord.
Yes.
My lord, the office objection, my lord, name of the petitioner is not tally with the impugned order, my lord. Because the land in question purchased prior to marriage, my lord. After marriage, my lord, the petitioner changed her name by adding her husband name, my lord. That's
What
why
is
they
impugned?
filed affidavit.
Where is the impugned order?
Impugned order, my lord,
Page number?
annexure at page 25, my lord. Typed page is page 27, my lord. Petitioner name is Shashi Murali Deshikan. Prior to marriage, Shashi Venkatachalam was her name, my lord. After marriage, she changed her name by adding her husband name, my lord. That's why they
They
filed
stated
affidavit.
in the before the assistant commissioner, the first and second petitioner were described by their maiden names, and thereafter, in the writ petition, they have been described by the names that they have adopted after their marriage. This submission is accepted. Then ಬೇರೆ ಏನೋ ಇದೆ memo for furnishing copy of affidavit.
ಅಲ್ಲ ಅದನ್ನೇ affidavit ಹಾಕಿದ್ದೀನಿ ಸಮಯದಲ್ಲಿ. I filed affidavit because marriage certificate was not available. That's why the petitioner filed affidavit by stating that they married with some person. That's why their name has been changed.
An
At page
affidavit is
53,
also
madam.
filed by the first and second petitioner to the same effect. About ಆಮೇಲೆ submission is accepted. Who's R4? Who's R4? Counsel for the petitioner files a memo seeking for dispensation notice to R4. So at his risk, notice to R4 is dispensed. Issue ಇದಾಗಿದೆಯಾ ರೂಲ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ ಪೋಸ್ಟ್ ಇನ್ ಬಿಲ್ ಆಫ್ಟರ್ 2 weeks. ನೋಡಿದ್ದೀರಾ? ಬರೀ ಸೆಕೆಂಡ್ ಸೇಲ್, second sale, fourth respondent. When was the original order passed? Where is the original order? But if he does not challenge it, Prakash, how can I permit you to challenge? No, but if he has accepted this order of forfeiture, when the order was passed on 14/8/2009, you are not in the picture. When you purchase the property, title was with the government, free from all encumbrances. You acquired no title.
My vendor has successfully contributed the affidavit of the private. Since he has not filed any further proceedings, I have filed the affidavit.
ಅವ್ರನ್ನ ಜೊತೆಲ್ಲ ಹಾಕೊಡಿ ಪಿಟಿಷನ್ ಆಗಿ, ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ಗೆ how can I entertain petition of yours? Technical ಅಲ್ಲ, it has ಸಿಗಲ್ವ ಅವರು ನಿಮ್ಗೆ ವಕಾಲತ್ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಡಿ. ಏನ್ ಹೇಳ್ಬೋದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ. If you get them on record as petitioner and accept it and call next week. Synopsis ಬೇರೆ ಹಾಕಿದ್ದಾರೆ. Synopsis ಬೇರೆ ಹಾಕಿದ್ದಾರೆ. ಏನು ಅಂತ old synopsis, old cost statement synopsis. Stitch ಮಾಡಬೇಕು. Change ಮಾಡಬೇಕು. So synopsis, ಒಳ್ಳೆ synopsis. Old synopsis. Synopsis letter. Old synopsis, distinction, old synopsis, statement synopsis to distinction. Week's time is granted to the council to furnish the old cost statement synopsis. New accurate application. Since the right to sue survives on the applicants in IA1/2022, the state application allowed. The applicants in IA1/2022 are permitted to come on record as the LRs of the third respondent. Cost rate to be amended. 2007. Post for hearing next Monday. Since the applicants in IA1/2016, since the right to sue survives to the applicants in IA1/2016, the said application is allowed and they are permitted to come on record. The applications filed for continuing the delay and for setting aside their judgment are also allowed. Who's R3? 2 weeks time is granted to take steps in respect of deceased R3. When did he die? In 2017 intermediate, you wanted to vacate it now? Post in B group after 2 weeks. Intermediate shall stand extended. In order. What was the order first? What was the order? Where is that memo? Memo date?
I appeal for third respondent.
25? ಒರಿಜಿನಲ್ ಇರಬೇಕಲ್ಲ ನಮ್ಮ ರೆಕಾರ್ಡ್. If I were to accept the cost shown I'm accepting that this gentleman filed this memo without the instructions of the council, without hearing it. Suppose he were to say that, no, he did give me instructions. I'll have, the council who filed the memo were to say that, no, he had instructions. No, you may say so many things in his absence. You were not aware as to what exactly transpired. If I accept whatever is said in your application, I'm basically accepting all the allegations that you made against the council. If you're saying that he had withdrawn the writ petition without instructions, if I accept it and you go to bar council, council is finished. If I accept the cause shown by you for recalling,
property, my lifelong earnings. All I'm saying is, my lord, here your merits. You have to property without hearing me.
and you waited for 2 years to make the application.
In your case, what's transpired, and not the property is involved. I'm only saying, give me merits, that's all, my lord. If I'm no case, this is the condition. That's all I'm saying.
You were heard, you were represented by council who chose to withdraw. You were represented by a council who chose to withdraw. It's very convenient now for you to come and say that the council had no instructions. Under the Vakala authority, you to come. I'm not making any accusation against you. If I have to accept this on behalf of the client, then tomorrow in a case of yours, he can come and say, I ask the council not to argue, not to do this negative argue. Where will the end of all this be?
That's all I'm saying. I'm not saying anything else. I'm only saying here you on the merits and then pass out. That's all I'm seeking. It's my property, Providence property. What I purchased to a state from a vendor. I'm not democracy, not the entire proceedings before the Assistant Commissioner and KAT, the error mentioned of this record.
2012 order, your client chose to challenge in 2017. Then petition is withdrawn.
I'm not party to proceedings before the AC and the KAT. I'm subsequently purchased.
From whom did you purchase?
From Krishnabad, not society, not the entire.
When you purchased it after the order of 17 NAB.
Yes. No, not so. At least all the records are.
The order of forfeiture was passed on 18th of September 2001.
Yes.
From that particular date,
Yes.
the property stood vested with the government free from all encumbrances. One minute.
Yes.
When did you purchase?
Subsequently.
When?
All the records are there.
When you purchased, you got no title. Your vendor challenged this order.
Yes.
Suffered an order.
Yes.
Then he challenged this again by filing a writ petition.
Yes.
Now you filed the writ petition.
No, not only he, there are a series of writ petitions filed. Totally, area was, let me finish. Total area was 68 acres. I'm not the only one. The entire balancing this order is, I tell you, the AC and the KAT that I put this to society. It is not so. Tell you about the orders. I put it from individual.
My problem is you purchase the property after the land stood vested free from all encumbrances with the state. You have acquired absolutely no title.
Stay by the KAT, by the AC, by this court until recently also. When all
So we will accept that argument.
Yes.
What about section 52? You are a pendant late purchaser.
Yes.
You suffer the consequences.
All of them have got live, except me. All the persons will not.
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಆಗಿದೆ. ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಅನುಕೂಲ ಆಗಿದೆ.
ಹೌದು. Not this year.
Where?
It's along with the memo.
Which memo? This order.
This is the very court, my lords. I've given the list all the petitioners. Last order, this is my own order. Last. All of them got relief, all of them. And this very council has filed a paper for all of them. Well, other council.
So you woke up after this order was passed.
No. This is passed recently.
When did you make the application?
2021. This one was passed 2022, or April, May. But this is MA. Much before that, I filed the application.
Not accurate application. Because 19 March.
That is the order. I don't appreciate about 100 crore applications before this court.
Where's your application?
Beginning, the beginning. No,
So still worse. That means was sometime during November 19, when the petitioner met his advocate, he was informed that the petition was withdrawn as the Leonard Single judge who was hearing the matter was intent to dismiss the petition.
that's what they have to inform. I'm going to kindly have a look at the order regards. Like, we have filed objection.
ಏನಂತ
The applicant filed objection to recall the order.
ಅಲ್ಲ, the reason why I am swaying towards him is this order passed by the KT in appeal number 610/2001, which is also impugned in this writ petition, has been set aside in a batch of writ petitions. And this application was filed on 19th of March 2021. The order is passed on 30th of March 2021. It's not like as if we made this application after an order was obtained. ಅನ್ಯಾಯ ಆಗಲ್ವಾ? ಎಲ್ಲರಿಗೂ ಒಂದು ಆರ್ಡರ್ ಆಗಿ ಇವ್ರಿಗೂ ಒಂದು ಆರ್ಡರ್ ಆಗಿ.
One line though. I have purchased.
That is the only thing. If you had made the application after this order, I would have dismissed it. When you,
My lord, one submission, there is no prayer against the BBMP, and let them not take advantage of any order, because
I am
BBMP.
only restoring the writ petition on file. That is all. An application is filed on when was the dismissal?
25/1/2018.
25/2/2018. 25/1/2018. The writ petition filed by the petitioner was dismissed as withdrawn on the basis of a memo which has been filed, which was filed by the counsel of the petitioner. It is stated in the application that the petitioner had not instructed his counsel to file the memo and withdraw the writ petition. It is seen from the memo for withdrawal that the memo filed before the court does not contain the signature of the petitioner. In that view of the matter, in my view, it would be appropriate to recall the order dated 25/1/2018 and restore the writ petition to file. IA is accordingly allowed. Next week on date code.
Hello?
Obliged.
Yeah.
One. 166. Next area 166 agreement of sale. He has doubted the grant. Internal page. What is your claim? What is the grantee's name? Huh? Why are you reading this? What is internal page 5? Page 5 of 12th. Na? No, at page number 217, the second paragraph after the tabular column. No, dear. ತಾಲೂಕು ಮೋಚನೆದಾರರು ಸರ್ವೆ ನಂಬರ್ 15 RTCಯಲ್ಲಿ 8 ಎಕರೆ ಶಿವಲಿಂಗಮ್ಮ ಅವರ ಹೆಸರಿಗಿದ್ದು, ಸರ್ವೆ ನಂಬರ್ 17ರಲ್ಲಿ ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಗೂ ಲಕ್ಷ್ಮಮ್ಮ ಅವರ ಹೆಸರಿನಲ್ಲಿ ತಲಾ 8 ಎಕರೆ ಅಂತ ಒಟ್ಟು 24 ಎಕರೆ ಬೋಗಸ್ ಆಗಿರೋ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ರದ್ದು ಮಾಡಬೇಕಾಗಿರುತ್ತದೆ ಎಂದು ಮತ್ತು 16ರಲ್ಲಿ ಬಾಕಿ ಇರುವ ಜಮೀನಿಗೆ ಮಂಜೂರುದಾರರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ. So this was a suspicion that he had. Yes. But from 54, their names were there in the records. Did you have anything prior to this 1990-91? No, Sagolichit, they're doubting because it's been inserted. Do you have anything to show when your name was entered in the revenue records for the first time? No, 53 if the Sagolichit is issued. 54 or 55, there should be a mutation order in your favor. So from that time till 1990, for 40 years, if your name is there. And which year? Then, so for 20 years, there was no mutation in your favor. Page number, which is that page? Page number? $50. What is the comment on this mutation list extract? No, if there's a mutation in the year 64, 65. No. What does he talk about this? You should doubt this also. 54, 55 grand. 64, 65, there is mutation list extract. If he does not comment on this. No, more than the grant records. He is right when he says you cannot go into the validity of the grant in a 136.3 proceedings. Right, there may be insertions, but if you allow those revenue entries to stand from 64, how has the Deputy Commissioner met this MR 8 per 64, 65? Does he say that no, there is no such MR, or this MR is also bogus? He may say that MR 8 by 65 is bogus, therefore I will not allow the entries to stand. If he does not comment on MR 8 by 65, 65. One? ಏನಿದ್ದಂಗಿಲ್ಲ ಶ್ರೀನಿವಾಸ 65 ಮೇಲೆ ಏನು ಮಾತಾಡಿಲ್ಲ. No, but he can only be concerned with the revenue entries. If the revenue entries are based on this MR 8 by 64, 65. That's why I said, where is he talked about MR 8 by 64, 65? Where have you said in this revision petition that you are the respondent, isn't it? Where have you referred to this MR 8 by 64, 65? That is a different thing. I am only concerned with the revenue entries. If you are now for the first time saying that your entries were brought into the records on the basis of MR 8 by 64, 65, where did you narrate that before the Deputy Commissioner? Where is? get instructions, see the records. If this MR 8/6465 is followed in some revenue records, then it is the case of the petitioners that their names were entered in the revenue records pursuant to MR 8/64-65. The learned AG is directed to ascertain whether MR 8/64-65 was indeed passed and whether it has been followed by entries in the revenue records. Relist on. You can produce something from 64-65. There can be only one MR. How can there be two MRs? Your case is doubtful, but there is some point in yours saying that after 64-65, if you can show that your names were in the records for a prolonged period of time, I'll accept it. Or else, ಮುಂಚಿನ ನೋಡಿ MR 8/64-65 ಅಲ್ಲಿ ಇದ್ರೆ ಫಸ್ಟ್ ಅದು MR 8/64 ಇದೆಯೋ ಅದನ್ನ ನೋಡ್ಬೋದು. When do you want? Who has sought for vacating? Who has sought for vacating? Which kade bandu ನೀವು ಕಡೆ ಬಂದು he has made the application. How can you argue on his behalf? True, but you have not made any application for vacating. Are you supporting the petitioner? Then wait, let us hear them first. When was interim order granted? Shall not demolish any existing houses or damaging existing trees or plantation. You want to demolish the trees and the houses? No, the interim order is only not to demolish any existing houses or damage existing trees or plantation or crops in land breaks number 3, 8, 15, 20, 31, 54 and 74. ಅಲ್ಲ ನೀವು ಮನೆ ಹೊಡೆದಾಕ್ತೀರಾ? Facts ಹೇಳಿ, but what is the point if the interim order is vacated and if you demolish the houses or remove the crops? Rule issue ಆಗಿದೆಯಾ? Those were posted in the group after 2 weeks. You were heard in the matter before this order was passed? You completed them afterwards. You appear for the respondent? That is what I said. I'll have it after 2 weeks. 2 weeks. 2 weeks. You not even made an application for vacating because he made the application. I'm saying list it after 2 weeks. 29th. Oh, idena? Against? Last time ನೀವೇ ಅಲ್ವಾ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನೀವೇ ಅಲ್ವಾ ಟೈಮ್ ಕೇಳಿ. So next non-mail complaint ಆಗುತ್ತೆ ಆರ್ಡರ್ ಮಾಡಿ. The matter is not going to be disposed of now. He is not ready. He is not ready. That's what I fixed now for a B group. What is that? File it in the registry. It will come up. File it in the registry. They'll scrutinize it and then file it. Give a copy to him. Post in B group on date could have to 29th. ನೀವು ಅದಕ್ಕೆ ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಬಾಯ್ ಬಿಡ್ಬೇಕು. ಸುಮ್ಮನೆ ಇದ್ರೆ
my lord, I am appearing for the petitioner, my lord.
yes.
My lord, the honorable court has directed to post two more matters which are connected with this matter. My lord, last occasion, in other two cases.
ಯಾವಾಗ post
On
WP, what's the number?
14th and 9th also, my lord, there are two. Yes, ma'am.
What is the number?
One is 16834, 16834 of 2021, and another is 15641 of 2021 WP minus.
Post to represent next Monday, next Wednesday.
Subsequently, as filed in the application form 57, based on that, the Tahsildar committee has passed the regulation before
Same other area, na? Same serial number? No, the order date is Leonard Council submits that in WP 16786 of 2021. This court has held that the petitioners, it is held that there is an alternative and efficacious remedy by way of an appeal under section 49 of the Land Revenue Act against an order passed by the Assistant Commissioner. In that view of the matter, this writ petition is disposed of, directing the petitioner to file an appeal before the Deputy Commissioner within a period of 1 month from today. If such an appeal is filed, the same shall be disposed of within 6 months thereafter. Until then, the petitioner shall not be dispossessed from land bearing survey number 30, measuring 3 acres 31 guntas of ಯಾವ village ಇದು? Of Karnataka village, Tekal Hogli, Malur Taluk. And the state shall also not initiate any criminal action against the petitioners under section 192 capital A and 192 capital B of the Land Revenue Act.
Page 212. Immediately in respect of the respondent, let's say, based on the register savings, was questioned with the year 2021.
Who are you?
From the purchaser.
From?
From my vendor's vendor, the savings exists from the year 1957.
By annexure L.
Yes, Madam.
It is said that the grant of 37 is valid.
That's 37 and never existed, Madam.
Why do you say that if he has found that there is a grant?
1937 grant. For the first time, after the lapse of 60 years, is being questioned before the authority.
You had filed the revision, correct?
I have not filed the revision. The respondent had filed the revision.
No, come to page 216.
Yes, Madam.
Last paragraph.
Yes, Madam. The player made the petition is to conduct an inquiry. So that is the respondent hearing. That is the respondent hearing that filed this revision, which is before the outcome.
No, this KM Raju.
Yes, Madam. Madam, I am two company, Madam. I am one of the purchaser.
From?
My father had purchased the property way back in the year 1960. My synopsis stated more.
KM Raju, Nagaraju, it is R5 and R6.
They came that there was a grant in the year 1938.
No, they sought for the inquiry to be conducted.
Yes, Madam.
Read that order portion from 216.
But before that, Commissioner has dismissed those proceedings. Being argued against the order passed in the aspect of some
They preferred an appeal under 136(2). Challenging what?
challenging the very revenue records.
No, challenging revenue records.
Connection.
Where is the AC's order?
131. Page 131. Connection.
They challenged MR 5/0304, MR 26/2004-2005, and MR 3/2019-20. Correct. Page number 130. Yes.
7 bar 57, 58, 65, 66, 3 bar 97, 96. Because these are the MRs challenged by the respondent. These came Raju and came Nagaraj. Plus the subsequent words, the order, the appeal was dismissed. Plus on 13/2021.
He has virtually now nullified the mutations from the year 57 and 58.
Actually, you not appear before the penalty for the assistant commissioner. We find a proper jurisdiction for the work that is substantially. Because work that is substantially, they say for the government authority is
Before the assistant commissioner, the appeal was under 136(2). You had preferred an appeal.
Not an appeal. During penalty level, we took the second opinion. During penalty level, before they say not a function. Then we thought work that is substantially.
Allah, what do you think, Allah? You had filed an appeal under 136(2).
Not an appeal. It's a original jurisdiction.
Why did you go to the assistant commissioner then?
So we took the second opinion.
The second opinion, yaar hatra tagondu?
Second opinion, senior alumni. So 136 is not the proper forum. You better go on to this.
Did you withdraw this appeal under 136(2)?
So then our proceed. In our objects.
But this special is not operating the plant that is made. It can only two more of one. Wherever the government and land is there, this report of the officer.
They did not raise the jurisdictional issue there. ಇವರೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. Where have they raised this contention before the special DC? They approach the special DC. Even then it is bad then. You should withdraw that assistant commissioner appeal then. ಏನ್ ಮಾಡ್ತೀರಾ ಅವಾಗ? Suppose I accept this contention. No, suppose I accept this contention that the special DC has no jurisdiction. ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತಾ? The special DC had no jurisdiction to entertain this revision under 136(3). So assuming that on a second opinion you approach the DC directly, this particular DC had no jurisdiction. So I set aside this order and send it back to the appropriate deputy commissioner. He will decide the matter afresh. 23rd account. Call on 23rd along with WP number. GTL work put. ಏನು ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಾ? ಏನಾದ್ರು ನಾಟ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ? Till then the respondent shall not split the matters.
On the basis of the Tassildar's report, looking at the grant, 7/2/13, the state commissioner
Next year ಏನ?
treat this as a petition under section 25 and appeal.
But DC ಗೆ appeal ಇದೆ.
But he has no jurisdiction. But he has entertained the appeal on the report of the Tasildar after we got the 50 years of the.
Who had granted the land? Which authority had granted the land?
Year 46 or 45. Then I am the first purchaser is under 1948. I purchased in the year 64-65. Can you see what the mutation entry has been done by the page 49?
Next ನೋಡಿ ಅದು. EG accepts. But after how many years? Oh, can you cancel the grant after so many years? ಏನ್ ಮಾಡಿದ್ದಾರೆ? No, this the subject, the subject talks about cancellation of the grant.
Proceedings are initiated on the report of the Tasildar, doubting that there are no grant accounts. Again, Lord, he has directed the Tasildar to
ಇದೇನಿದೆ ಅರ್ಥ? ಮತ್ತೊಮ್ಮೆ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಮತ್ತೆ then why did he pass the earlier order cancelling all the mutations if he was not very sure about the grants? ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇನ್ನೊಂದ್ಸಲ ಪರಿಶೀಲನೆ ಮಾಡಿ ಅಂತಾರೆ. No, According to this, for the first paragraph, Prastavana, page 115. No, this was the reference. ಮೂಲ ಮಂಜೂರಿ ದಾಖಲೆಗಳು ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆ ನಡೆಸಲು ವರದಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. Can you conduct an inquiry only on the basis that no records are available with you? And in the subject, it talks about cancellation of the grant. Either you should have a specific case saying that there is no grant or there is a grant, cancel the grant for violation. ಇದು ವಿಚಾರಣೆ ಮಾಡಿ ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಶ್ರೀನಿವಾಸ್ ಯಾವಾಗ ನೀವು ಎದ್ದೇಳ್ತೀರ ಅವಾಗೆಲ್ಲಾನು whenever you don't maintain records, they have to come and suffer the consequence. This argument is going to be advanced forever, for all time to come. ಇದರ ಪ್ರಕಾರ ಗ್ರಾಂಟ್ ಯಾವಾಗ ಆಗಿದ್ದು ಅವ್ರ ಪ್ರಕಾರ ಗ್ರಾಂಟ್ ಅಲ್ಲ ಯಾವಾಗ ನೀವ್ ಹೇಳಿ ಡೇಟೆಡ್ ಅಂದಾಜು ನಿಮ್ ಎಜಿ ಆಫೀಸಲ್ಲಿ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಫೈಲ್ ಮಿಸ್ ಆಗುತ್ತೆ ಇದು 64-65 ಗ್ರಾಂಟ್ ಆಗಿದ್ದು ಯು ಗೆಟ್ ಅಪ್ ಒನ್ ಡೇ ಅಂಡ್ ಸೇ ದಟ್ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ದ ರೆಕಾರ್ಡ್ಸ್ therefore conduct an inquiry as to whether there is a grant or not. Is such a power available to the assistant commissioner to make an inquiry? That is your problem. What is the grantee do? So ನೀವು specific proceeding ಶುರು ಮಾಡಿದ್ರೆ election for cancellation or under 136 to the deputy commissioner saying that the entries that are made are without any basis. But ಇವಾಗ ಸುಮ್ಮನೆ ಅದು ಕಲೆಕ್ಷನ್ ಅಷ್ಟೇ ಅವ್ರ ಹತ್ರ ಇರಲ್ಲ 50 ವರ್ಷ ಹಳೇದು ಹಿಂಗ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಹಂಗ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಎಕರೆಗೆ ಇಷ್ಟು ಅಂತ ಅಷ್ಟೇ. Learned AG accepts notice for respondents. There should be interim stay. All further proceedings pursuant to annexure A. ಏನಕ್ಕೆ ಅಡ್ಜರ್ನ್ ಆಗಿದ್ದು ನಿಮ್ಗೇನು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾಳೆ ನಾನು The application is in the name of application. Where's the application? Which? Amaya bin Muniappa. Amayama bin Muniappa. ಅಲ್ಲ ಅದು ಕೊಟ್ಟಿದ್ರೆ ನಾನು ಎಕ್ಸಾಮಿನ್ ಅವ್ರ page.
ಈ ಪೈಕಿ ಕಚೇರಿ ಕೋಮ್ ಬೆಳ್ಳಪ್ಪನವರಿಗೆ ಮಂಜೂರಾಗಿದ್ದು ಅಧಿಕೃತ ನಾಮದಲ್ಲಿ ಕೋಮ್ ಬದಲಾಗಿ ಪಿನ್ ಎಂದು ಮತ್ತು ಬೆಳ್ಳಪ್ಪ ಅವರ ಬದಲಾಗಿ ಮುನಿಯಪ್ಪ ಎಂದು ಒಡೆದು ಬರೆದಿರುವುದು ಮೂಲ ಕಡೆಗಳಿಂದ ಪರಿಶೀಲನೆಯಿಂದ ಕಂಡು ಬಂದಿದೆ. ಆ ಕೋಮ್ ಪಿನ್ ಅಂತ ಮಾಡೋದು
What does the deputy commissioner say?
Deputy commissioner already release ಮಾಡ್ತಾರೆ. So release document ನಲ್ಲಿ he cannot interfere. They already issues are pending. In fact, we are not starting to respond.
In the unwritten RTC, it's shown as daughter of Muniappa. No, but in para
2015, they gave an application for us to correct the RTC entry, and thereafter the order was passed.
the Samayama actually released it in favor of respondents 3 to 8.
Change ಮಾಡಿ immediate transfer related funds. The impact is today Ammayama up to 1978 to 2015.
But there is no record to indicate. Don't invite a finding from me. Go to civil court. For what? Prayer in. No, if they are sought for declaration that they are the owners, and as a consequence, declare. Plaint ಅಲ್ರಿ plaint. ನೀವು ಚೂರ್ ಚೂರೇ ಕೊಡ್ತೀರ ರೆಕಾರ್ಡ್ ನನಗೆ ಆಮೇಲೆ ಕೇಳಿದ್ರೆ ಕುಡಿಸಲಿದ್ದಾರೆ ಅಂತ ಅಂತೀರ. Madam, to declare that the plaintiff is the absolute owner of the suit properties and is in peaceful possession. That is a prayer. Civil court will decree ನೀವು ಗೆದ್ರೆ ಅವಾಗ ಚೇಂಜ್ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ನೀವು ಫಸ್ಟ್ ಡಿಕ್ಲರೇಷನ್ ಸಿಕ್ಕಿದ್ರೆ ಓನರ್ ಅಂತ ರಿಲೀಸ್ ಇಟ್ ಆಟೋಮೆಟಿಕ್ ಹೋಗುತ್ತೆ. ಕರೆಕ್ಟ್ ಮಾಡೋದು. Why I am dismissing this petition, asking him to go away. This petition. ಅದನ್ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿ. Why? I will nullify suit if I say anything here. This writ petition is filed, challenging the dismissal of a revision petition filed under section 136 capital subclass 3 of the Land Revenue Act. The proceedings for mutation in respect of land bearing survey number 132 measuring 2 acres, on the basis of the registered release deed executed by Ammayamma, daughter of Muniappa. The entries were changed in favor of her children, respondents 3 to 8. ಅದ್ರ ಮೇಲೆ ಅಲ್ವಾ ನೀವು ಹೋಗಿದ್ದು? ಅಲ್ಲ, ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ದು ಅದ್ರ ಮೇಲೆ ತಾನೆ? She preferred an appeal. On the basis of release deed executed by Ammayamma, wife of Muniappa, daughter of Muniappa. This entry was challenged by the petitioner, who claims that she is Ammayamma, wife of Muniappa. It is her case that the land was granted to Ammayamma, wife of Muniappa, and not Ammayamma, daughter of Muniappa. It is also contended that the revenue entries and the grant certificate and the revenue entries indicated that the land was granted in favor of Ammayamma, wife of Muniappa. The Assistant Commissioner, however, rejected the appeal, and the Deputy Commissioner has also confirmed the said order. Then, counsel for the petitioner fairly submits that Ammayamma, wife of Muniappa, that is the petitioner therein, has instituted OS 503/2021, seeking for a declaration that she is the absolute owner of the suit properties and is in peaceful possession and enjoyment of the suit properties. A prayer is also made in the suit to declare that the registered release deed executed in favor of respondents 3 to 8 herein as not binding on her. In view of the fact that a civil suit has been instituted with the petitioner, there is absolutely no ground to entertain this writ petition. The writ petition is accordingly dismissed. It is needless to state that in the event of a decree being passed in favor of the present petitioner, the revenue entries will abide by the said decree. Subject to the above, writ petition is dismissed. Next step. So amount of for what?
And in this, an image number 27, right? And the absolute polar and purchase and survey number 158. Right now. Image number 27. In the include order. Paragraph number 3, line number 2. There is survey number 158. Find the owner and in absolute possession of the property. Right? In this particular zone of the proceedings,
Which is your survey number? Which is your survey number?
158. That was not made a part. And
You are not made a party before this.
please, my lord, in the zone of the proceedings.
Whether are they parties or not?
The respondent number 20, Mr. Gopal, is the one who sold the property.
Your vendor is a party. When did he sell the property? Then did he inform the authority that he had sold it?
No,
How can you find? How can you find fault with the authorities if? No. Nobody knew that you had purchased the property until your vendor had informed the authority, saying that you've already sold the property and I have no subsisting interest. Or did your vendor appear before the authority? Where is it said about his stand? What stand has he taken? What can the no, but what can this authority do if he does not inform them that he has sold the property?
Two aspects. One, the system said that consent is not made a party before my lord. Before this court, and I made Mr. Gopal the party. I really don't know on this written submissions it has submitted to the authorities. Even otherwise, when I am in the absolute ownership of the property right now, I will need an opportunity to demonstrate my case.
When did you purchase the property?
14 July 2020. Next year, I have produced the property information.
When was the entries change in your favor?
Yes.
Was the Kata standing in your name?
Yes, ma'am.
As on when? Where is it? Where are the revenue records?
But you found that it's already changed in my favor.
And because the reason I'm asking you all these questions is more than one survey number is involved.
Correct.
And if at your instance,
respondents have already approached this court. I have just come to know on my checked on the NCR number. This order, the concurrent bench has considered for one of the parties. But there was a party before that proceedings. My case is different as I was never even arrayed as a party there.
are you sure that this order is against the same?
Please, my lord, please.
It is submitted. It is submitted that the order impugned in this petition, that is the order dated 11th of March 2022 has already been challenged by the other respondents and are challenged by persons who had been arrayed as respondents before the commissioner in WP 9046/2022, and this court has ordered notices to the respondents and has also granted an interim stay of the order implementing the said petition. In view of this submission, issue notice to the respondents when an AGA accepts notice for respondents 1 to 7. There shall also be an interim stay of annexure A till the next date of hearing. Post this petition along with WP 9046/2022. IA 2/22 for dispensation is allowed.
Subject matter to stage 29.5 acres of land. In survey number 69 of the Gujarat but in this case, the challenge is that the order of the deputy commissioner, page 28.
ನಿಮ್ಮಲ್ಲಿ ಕೇಟಿಗೆ ಅಪೀಲ್ ಇಲ್ಲ.
I will submit. Because the lordship tendency on the part provision of law, this order is passed in the law. Number 2, my lord, there is no right, no legal rights or any power of the deputy commissioner to pass such an order. I'll demonstrate how it is. 79 class 2 of the Land Revenue Act is the lordship act. Okay. Section 79 of the Land Revenue Act.
$79.
79 class 2. Very notwithstanding anything contained in subsection 1, but subject to such general or special orders that may be issued by the state government from time to time. This is the one. Only the state government is having any right to withdraw a right on the complete privilege right.
Subject to the general orders.
Yes.
Suppose there is an order of the special of the government, general or special, that will hold the field. If there is no general or special orders, then the deputy commissioner can proceed to pass orders. They are subject to that. Read it once again if you want to. Or let him satisfy himself.
Notwithstanding anything contained in subsection 1, but subject to such general or special orders that may be issued by the state government from time to time.
So he can exercise this power subject to the general or special orders.
Yes.
Suppose a special order of the government that will prevail, he cannot exercise. So until you show me that there is special general order which prohibits a DC from withdrawing the Kumki privileges,
Not only when the state government passes special orders in respect of withdrawing the, well, this is an order, this is a privilege.
that
Which
will
is
be
continued.
that will be a wrong reading of such a subsection.
This is the continued even under section 202 of the Land Revenue Act.
Whenever any statutory provision says it is subject to some special or general orders, that means it is a contrary order that will prevail and not this. This is basically an enabling power of the deputy commissioner. But this is not an absolute power. It is made subject to this an order by the government.
Only when the state government passes such an order.
So no, if you were to say that the government has passed some order in respect to this particular area, then the DC loses its jurisdiction. The special order will govern. Where is such a special order by the government?
Well, there is no special order by the.
Then he has the power. Then he has the power. I think it's better you prefer an appeal. This is original order, alva?
But there is no provision. This is not being passed with any provision of law.
This is an original.
Practicing the order.
This is an original order passed with the deputy commissioner. Section 49. The order impugned is an original order passed with the deputy commissioner, which is amenable to an appeal under section 49 of the Land Revenue Act. When it comes to the petitioner, in view of this, seeks for permission to withdraw this petition and also seeks for reserving liberty to the petitioner to avail the appellate remedy. The writ petition is dismissed, reserving liberty to the petitioner to avail the appellate remedy provided under section 14 of the Land Revenue Act. 29. 24. What is annexure K and L? And L? KC का appeal है.
The application is of the year 1991, now, after the, this report has directed them, now they have considered rejected.
ಹಾಕ್ಲೇ ಬರ್ದಾಗಿತ್ತು writ petition. ಸುಮ್ಮನೆ ಇದ್ದಿದ್ರೆ ಹಂಗೆ ಪೆಂಡ್
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾ
ಇದರ ಮೇಲೆ ಎಸಿಗೆ ಅಪೀಲ್ ಇದೆ, ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಅಪೀಲ್ ಇದೆ. ಈಗ ಮಾರ್ಚ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ನಮಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದೆ ಅವರು
Productive for 2 weeks. In 2 weeks, prefer an appeal and seek for as against the impugned orders, as against the impugned order, the petitioner has the remedy of filing an appeal to the Assistant Commissioner. In view of the above, the petition is dismissed, reserving liberty to the petitioner. Prefer an appeal to the Assistant Commissioner. For a period of 2 weeks, the petitioner, no action shall be taken against the petitioner. If an appeal is not filed within 2 weeks and an interim order is not obtained, this interim order will stand automatically dissolved. This was a 136-2. DC Goglu. If this is an order under 136-2, you have to go on.
It is that the review petition. So I'm challenging the order passing the review matters. That is annexure C.
Where is the original order?
Annexure B matters.
He has reviewed his earlier order.
The petition is really in favor of the husband of the petitioner was challenged with respondent number 5 matters. And in fact, it has clarified with the particular land matters. So the respondent number was making observation that as per the registered partition lead matters, limitation exists.
ಮಾಡಕ್ ಬರುತ್ತಾ ಶ್ರೀನಿವಾಸ್?
No matters. Respondent number 1 is not having any authority to review.
Issue notice. When a AG accepts notice, the respondents 1, 2, 4. So there should be an interim stay of all further proceedings pursuant to annexure C. ಏನ್ ಮಾಡೋದು? Next year A to D. Next year K. It is the case of the petitioner. How committee are at the missing records rebuilding committee had passed an order on 22/12/2021 laying down the procedure for rebuilding the records. It is the case of the petitioners that a series of representations have been made to the authorities to act in accordance with the said guidelines and rebuild the records and conduct a Podi and Durasti. And despite several representations, no action has been taken. In my view, since the petitioners are seeking for rebuilding of the records and for conduct of a Durasti and Pod on the basis of an order of the committee, it would be incumbent on the part of respondents 3 to 6 to consider the representation of the petitioners and pass appropriate accordance in law within a period of 3 months from the date of receipt of a copy of this order. AC.
The 136 talented mutation in India, on 7/4/2022, grant the interim order. After issue notice, 7/4 interim order. The objection ಆಗ್ತಿದೆ. ಏನು ಮಾಡಿಲ್ಲ ಏನಿಲ್ಲ. Stay vacated. Stay. ಮುಂದೆ ಲೈನ್
7 ಅಲ್ಲ 17/4 ಇದೆ.
12/4.
12/4.
12/4 stay vacated ಅಂತ ಹೇಳೋದು. ಅವರು stay vacated ಮಾಡ್ತಿಲ್ಲ, only statement of objection ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. 7/4 ಕೊಟ್ಟಿದ್ದಾರೆ, 12/4 ಕೊಟ್ಟಿದ್ದಾರೆ.
Issue notice. ಅವ್ರನ್ನ ಕೇಳಬೇಕಲ್ಲ ಇಶ್ಯೂ ನೋಟಿಸ್ ಲರ್ನಡ್ AG accept notice for R1 and R2 in the next date of hearing. ಏನ್ ಸ್ಟೇ ಕೇಳಿದ್ ನೀವು ಅಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ ಸ್ಟೇ ಎಲ್ಲಿದೆ ಅದು? ಇಲ್ಲ ಇಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿದೆ ಇಲ್ಲ ಎಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಅರ್ಜಿಯಲ್ಲಿ ಎಲ್ಲಿ ಕೊಟ್ಟಿದೆ ಸ್ಟೇಟ್ ಸೇಮ್ ಇಲ್ಲ ಎಲ್ಲಿ ಪೇಜ್ ಅನೆಕ್ಸ್ ಅರ್ಜಿ ಬನ್ನಿ ಪೇಜ್ 89 ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರ ಎಲ್ಲಿ ಯಾವತ್ತು ಕೊಟ್ರು? ಇಲ್ಲ ಸ್ಟೇ ವೆಕೇಟ್ ಅಂತ ಬರೋದು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ಯಾವ? 7/4 ಇಲ್ವೇ ಇಲ್ಲ ಇದರಲ್ಲಿ. An interim stay of the order of the Tahsildar. ಅಲ್ಲ ಸ್ಟೇಟ್ ಕಮಿಷನರ್ ಸ್ಟೇನ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರೆ ಸ್ಟೇ ಇದ್ರಂಗೆ ಆಗ್ಬಿಡುತ್ತೆ. I have to grant the order passed in stay the order of the ತಹಸೀಲ್ದಾರ್ ಮಳವಳ್ಳಿ ಇನ್ RR ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಏನೋ ನ್ಯಾಯ ಅಂತ ಇದೆ CR 217/2021 and MR T85/21-22. Sir. Sir. What should I do? And this was on non-prosecution. 2012, 13 matter. I've granted you time how many times? I do not embarrass you. What do you want me to do? File a memo for retirement enclosing the registered acknowledgement or that receipt. I'll accept it and dismiss it non-prosecution. You want me to pass it over or you want me to? I need that receipt also. Yes, sir.
I'm for the respondents in this. In fact, the matter I on the last occasion, I had submitted before this honorable court that the matter has been settled. Now, all the petitioners, including the general power of attorney holder, have sworn affidavit. One of the affidavits is before your lordship. I'm sorry because they have not cooperated for about for the last 1 year. I and the petitioners council have been asking them whether the matter is settled. Now they have sent one power of attorney holder as well as the rest of the two petitioners. My colleague is there. That two affidavits of the court is there. Because however much we tried, they never reported, my lord, settlement even. Now they are sending.
Or is there some
petitioners themselves, both the petitioner and the power of attorney holder as well. They don't want to proceed.
He has now produced an affidavit of P1 and P2.
Yes.
Your clients.
Way back in 2015 and 11 years ago.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಅಲ್ವಾ ಅಷ್ಟೇ ಹೇಳಿದ್ರು ನಿಮ್ ಕ್ಲೈಂಟ್ ಆದ್ರೆ ಇನ್ನ
They have not cooperated. I do admit, my lord. ಒಂದು ವರ್ಷದಿಂದ ನಾನು
they'll accept this memo and close affidavit and close it.
Yes, if he is
ವಿರುದ್ಧವಾಗಿತ್ತಾ? You have filed only the affidavit of this Stella?
And also today the two affidavits today, my lord. Yesterday I had that power of attorney holder third petitioner, and today the two affidavits in the open court, my lord. My colleague must have.
Learned counsel for National Respondent?
RNA respondent. And one more application I filed to implead the builder who has purchased the property.
No, I will simply accept this and dismiss it on the ground that he has no instructions.
Yes, sir.
The non-counsel 6 respondent has filed. Affidavit ಮೇಲೆ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ. ಅವ್ರ affidavit ತಪ್ಪಿದ್ರೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
Yes.
ಅಲ್ಲ, I'm putting it on his side. ಅವ್ರ affidavit ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. Two memos dated 14/6/2022 and 15/6/2022. Along with these memos, affidavits of the first, second, and the third petitioners are filed. In the affidavit, it is stated that the petitioners had settled the matter by filing a compromise petition on 6/10/2015 in OS number 255/2010, and they do not intend to prosecute the writ petition on merits, and the same may be dismissed. Next part. When counsel for the petitioner, however, submits that he has no instructions and the parties have not in contact with him despite his best efforts. Next part. In view of the above submissions, since the petitioners are stated to have filed an affidavit, since the sixth respondent states that they have been furnished with affidavits of the petitioners stating that they do not intend to prosecute the writ petition, at the risk of the respondent number 6, the affidavits are accepted and the writ petitions are dismissed. So if the petitioners are to dispute this affidavit, they are at liberty to make appropriate applications in this very writ petition.
Application for unauthorized occupation. Large quantity produced. But kindly look at the annexure B.
Annexure?
B, page number 32.
Yes.
This is my.
You had sought for 393/4D1. You had sought for 393/4D1.
There were two applications. Confusion was under form number 50 and one under form number 53. My form number 50 was rejected. That the order is under report directed to be produced. Because in the order of the assistant deputy commissioner.
No, annexure B is form number 53.
Correct. Even a rejection order. E-application rejection order. Date is now noted.
94.
Oh, if the application 99.
So your first application was rejected in 1994.
Please.
Then according to you, made the second application in
Annexure B in 1999. According to me, it's pending. But now, a rival claimant had filed an application for same for different claim, which is at annexure D. Application is at annexure D.
annexure.
D, page number 39. November.
This is also in the 99? 98.
98. December 98.
This is by which respondent?
Respondent number 2.
This is in respect of 339/4.
Oh.
D1.
Oh.
And he has been granted this 393 bar.
So same land which I had applied for.
That is 393 bar 4.
393 bar 4 D1.
So according to your second application is pending. Can you make a second application?
This is annexure D second application.
Madboda, after once it is rejected.
That is the question asked by the court on the last date of hearing. But there are two provisions, 94A and 94B. Section 94A and 94B. Otherly difference here will 94A only if a particular person had a particular extent of land, he was ineligible.
According to you, this is the first application under 94A?
Yes, because 94B has come up only in 1999.
Let us see the difference between 94A and B.
Please, my lords. Lords, 94A, maybe.
Yes.
Subject to such rules as may be prescribed, the state government shall by notification constitute for each constituency of the legislative committee consisting of such a number of members not exceeding 5. Of whom one shall be member of this and so and so. Kindly come to section 2. The Tahsildar of the concerned taluk shall be the second. 2A. State government may, if it is of the opinion that it is necessary to constitute one more additional committee, I will skip it, madam. 3. The committee shall follow such procedure as may be prescribed. 4. Nothing in section 94 shall prevent the committee constituting section 1 or action from the so and so, but subject to such rules as may be prescribed. Any to grant the person liable to be evicted under that section. The land which he had another prior to the third date 2005, year after referred to said date, or any portion thereof, if he satisfies the prescribed condition, including the extent of land held and unauthorized held and unauthorized occupied by him, and makes within a period of 1 year from the date of commencement of Karnataka Land Revenue Amendment Act 2018, Kerala referred to as Amendment Act, an application for such grant in such form, along with such fees as may be prescribed on payment of the amount of research, provided that the land so granted together with the land already held by such person shall not exceed 2 hectares of B class of land or its equivalent there, provided further that no land shall be granted in the area so and so. But now this provision, B class land provision,
He did not make an application under 94A. Because come to the first proviso to 94B.
94B.
Yes, you are saying that your applications are 94B, both your application and his application.
Yes.
You are saying 94A is now concluded. You have accepted that. You made an application under 94B.
94B Kunki land avail ಮಾಡಲಿಕ್ಕೆ ಸರ್ ಈ 94B ಅನ್ನು ತಂದು legislature has brought it, including the Kunki land under section 79.
Including land referred to in subsection
79. 79 ನಲ್ಲಿ Kunki land ಅಂದ್ರೆ ನಮಗೆ where I have given to take fire etc. that equally equates to the conditions of Kunki land. So that is added. And the extent of land has been removed. Illegal 79B extent another. So that provision is different. And for B is different. So my submission before the.
But what is the effect of the dismissal of the first application? That means you are not an unauthorized occupation.
No.
What was the reason given?
Ali excess land. Ali D ಇದರಲ್ಲಿ ಅದರಲ್ಲಿ condition ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೇನೆ. Excess land ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು 94B ಅಲ್ಲಿ ಹೌದು, it is true.
But what about 94B subclause 2? It's applicable only for these candidates. Please read 94B subclause 2.
To grant of such land under section 94A as free to apply for such grant under subsection 4 of the section within a period of such time, and provided that nothing in this clause shall apply to a person who has become eligible for grant of land by virtue of Karnataka Land Revenue Amendment 1997.
94B actually reserves right only for those people who had not made the application under 94A. Here you have made an application, it is rejected.
On the ground that,
On whatever ground,
please,
94(2)
how,
reserves right only if you have not made the application.
how?
Once you made the application, it is rejected.
Yes.
How can you make a second application?
Even regarding the, that is one part.
That is a major part that is troubling me, because you had made an application, it was rejected. How can you now come back to 94B and say, though my earlier application is rejected, I still have the right under 94B.
Of course,
If that is not there, then there is
ಕುಮ್ಕಿ ರೈಟ್ ಈಗ ಕುಮ್ಕಿ ರೈಟ್ ಈಗ ನನ್ನ
ನಿಮ್ ಕುಮ್ಕಿ ರೇಟು ಯಾವ ರೇಟು ಒಂದು ಅರ್ಜಿ ಹಾಕ್ಬಿಟ್ಟು ನೀವು ಸೋತ್ಬಿಟ್ರಿ ಒಂದ್ಸಲ ಸೋತ್ಬಿಟ್ರೆ ವಾಟ್ ಎವರ್ ಯು ಕ್ಲೇಮ್ ಯು ಹ್ಯಾವ್
ಕುಮ್ಕಿ ರೈಟ್ ಇಸ್ ಟೋಟಲ್ ಆಲ್ಟುಗೆದರ್ ಡಿಫರೆಂಟ್ ರೈಟ್ಸ್ ಈಗ ಆ ಕುಮ್ಕಿ ರೈಟ್ ಇಸ್ section 94
by making the application under 94A you gave up your right for kumki privilege.
Because this kumki right is granted under good standing orders unless ಆ kumki right ಅನ್ನು ವಿರಹಿತಪಡಿಸುವುದು ಮಾಡಲು ಅದು ಹೋಗುದಿಲ್ಲ. ಈಗ ನನ್ನನ್ನು ಹೇಗೆ ಮಾಡಿ ಇದೊಂದು issuing notice to me second current to the same person.
Where is the order granting you kumki privilege? Where is the order granting you kumki privilege?
My lord goes along with the worker property. My lord,
you assume that ಅಷ್ಟೇ.
ಅಲ್ಲ ಹೌದು ಅಲ್ಲ ವರ್ಗ ಪ್ರಾಪರ್ಟಿಗೆ ಕುಮ್ಕಿ ಪ್ರಿವಿಲೇಜ್ ಪ್ರಾಕ್ಟಿಕಲ್ ಇದೆ. There is no dispute on that.
Correct ಇದೆ. But the moment you went under 94A,
correct,
you are not claiming kumki privilege.
ಇಲ್ಲ ಹಾಗೆ
You look at your conduct. Once you claim you're an unauthorized occupant, you lose. The moment you lose, you file a application under 94B.
please,
Now, if you lose 94B, you say, I still have kumki privilege. So, at somehow or the other, you want to make a claim. You should be at least clear in one. Kumki privilege, 94E or 94B. Another shifting stands to me.
spite of 94A and 94B, my kumki privilege is not extinguished. There should be an express order by the government extinguishing my kumki right.
That is if you have a kumki rate, which is established, which is admitted. Who has admitted your kumki privilege? You have assumed that you have kumki privilege.
ಅದರ ಬಗ್ಗೆ ಅದು kumki land ರೈಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಇಷ್ಟವರೆಗೆ ಎಲ್ಲೂ dispute ಬರಲಿಲ್ಲ.
ಅಲ್ಲ ನೀವು ಎಲ್ಲೂ ರೈಸೇ ಮಾಡಲಿಲ್ಲ ಕುಮ್ಕಿ ಪ್ರಿವಿಲೇಜ್ ಎಲ್ಲ ರೈಸೇ ಮಾಡಲಿಲ್ಲ you conceded that it's you're an unauthorized occupation. If you are claiming kumki privilege, there's no question of unauthorized occupation. You only had the right, you had the privilege of using that land. Under 94B for the first time, a right is given to you to seek for grant of that land.
ಈಗ ನನ್ನ ಗ್ರಾಂಟ್
ಹಂಗಲ್ಲ ಶಿವರೇ ನಾನು ಹೇಳ್ತಿರೋದು
explain my position. I will be very clear. I don't claim any right of that land to grant me that land. My submission, granting of the land to second respondent, it is a second grant by suppression that has been obtained. That is under challenge before your life.
correct. My question, the reason with this controversy was I doubted your locus standi to challenge it. My understanding was, my understanding was having lost that. Now you are again raising this ground of kumki privilege. If you had a privilege of kumki over this particular land, you could not have claimed that you are unauthorized occupation. You would have simply said, I have a right, I don't have to seek for regularization. Angu,
because that time in the application, when the provision was granted, it was not clear that this could be done for the kumki land or not. Of course, 94BL, kumki and add ಮಾಡಿ section 74 ಅಲ್ಲಿ add ಮಾಡಿ. Probably because of that, they must have filed the application. Of course, I cannot say anything on that. Now,
ನಿಮ್ ಸಂಕಟ ಆಗಿದೆ ಅವ್ರು ಕೊಟ್ಬಿಟ್ರಲ್ಲ ನಾನು ಕೇಳಿದ್ದೆ ಅದನ್ನ.
ಅದು ನನ್ನ ಆಕ್ಯುಪೇಷನ್ ಅಲ್ಲಿ ಉಂಟು. And fraud
That
is claimed because may draw the attention of the court to annexure C claim number 37. Respondent number 2.
Where is the order now granted? Granted to R2, na? Where is the order of grant? Extra A.
Annexure is the order passed by
ಏನದು?
The order, the original order granting, to respondent number 2, 9 on the back side of the paper. Survey number 26. What he has applied, what was granted?
Where is the order? This is only a grant or certificate. Sagoli chit. Where is the order? Where is the resolution?
This itself is wrong. There is no further
There will be a resolution of the committee based on the recommendation of the Tahsildar, and thereafter the Sagoli chit is issued. This is the culmination of the proceedings.
That's what I don't have.
AC must have said that, isn't it?
AC already have done it, I'm telling you. But may I draw the attention of the board to annexed page number 45. The page number 46 may kindly be seen by now.
Read page 29. Let us read the order.
29 minutes. Here ಕೋರಿ ಇದರ ರಿವಿಷನ್ ಮಾಡ್ತಾರೆ ದಾಖಲು ಮಾಡ್ತಾರೆ ಪ್ರತಿಬಂಧ ಕಟ್ಟ ದಕ್ಷಿಣ ಮಾಡಲಾಗಿ ಮೊದಲನೇ ವಿಷಯ ಕನ್ಯಾನ ಕಂಟ್ರೋಲ್ ಪ್ರಕರಣ ಸಂಖ್ಯೆ 15 on the ಸರ್ವೆ ನಂಬರ್ 393 4 ಬಿ 1 ಬಿ ನಲ್ಲಿ 0.56 ಎಕರೆ ಜಮೀನನ್ನು ಭೂಮಿ ಜೀರಾಕ್ಷಿ ಸಂಪೂರ್ಣ ಮಾಡ್ತಾರೆ. ಸದರಿ ಆದೇಶವನ್ನು ಅಪೀಲ್ ದಾಖಲು ಮಾಡುವುದರ ಮೂಲಕ ಸದರಿ ಉಪಅಧಿಕಾರಿ ವಿಚಾರ ಮಾಡಿರ್ತಾರೆ. ಸದರಿ ಆದೇಶ ಅಪೀಲ ಜಿಲ್ಲಾಧಿಕಾರಿ ದಕ್ಷಿಣ ಜಿಲ್ಲೆಯವರು ಅಪೀಲ್ ದಾಖಲು ಮಾಡಿದ್ದಾರೆ. ಅದು ಸಹಜ ಆಗುತ್ತೆ. ಜಿಲ್ಲಾಧಿಕಾರಿ ಆದೇಶ ಮಾಡಿ ಒಂದು ವೇಳೆ ಒಂದನೇ ಎತ್ತುದಾರಿಗೆ 2 ಸಲ ಜಮೀನು ಮಂಜೂರಾಗಿದ್ದಾರೆ. ವಿಚಾರಣೆ ಮಾಡಿ ಕಾನೂನು ಪ್ರಕಾರ ಕಾಯ್ದುಕೊಂಡು ಬಂಟ್ವಾಳ ತಹಶೀಲ್ ನಿರ್ದೇಶನ ನೀಡುತ್ತೆ. ಆ ಪ್ರಕಾರ ತಹಶೀಲ್ದಾರ್ ವಿಚಾರಣೆ ಮಾಡಿದ್ದಾರೆ. ಒಂದನೇ ಎತ್ತುದಾರಿಗೆ ಬಂಟ್ವಾಳ ತಾಲೂಕು ಕನ್ಯಾಕುಮಾರಿ ಸರ್ವೆ ನಂಬರ್ 393 4 ಬಿ 1 ಬಿ ಹಾಗೂ ಕರವಟವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 451 ಬಿ 7ರಲ್ಲಿ 0.41 ಎಕರೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಆದರೆ ಕಾನೂನು ವಿಸ್ತರಣೆ 2 ಸರ್ವೆ ನಂಬರ್ ಮಂಜೂರಾಗಿದ್ದ ಜಮೀನಿನ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ ಕಡಿಮೆ ಇದೆ. ಜೊತೆಗೆ ಕರವಟವಾಡಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 471 ಬಿ 7ರಲ್ಲಿ 0.41 ಎಕರೆ ಮಂಜೂರಾಗಿದೆ. ಅದೇ ರೀತಿ ಸರ್ವೆ ನಂಬರ್ 393 4 ಬಿ 1 ಬಿ ನಲ್ಲಿ 0.56 ಎಕರೆ ಮಂಜೂರಾಗಿ ಕಾನೂನು ಅವಕಾಶ ಇಲ್ಲದಿದ್ದರೆ ಸರ್ವೆ ನಂಬರ್ 481 ಬಿ 7 ಕಾನೂನು ಜಮೀನಿನ ಮಂಜೂರಾತಿಯನ್ನು ಪ್ರತಿಪಕ್ಷವನ್ನು ಒಂದನೇ ತಹಶೀಲ್ದಾರ್ ಬಳಿ ವಿಚಾರಣೆ ಮೇಲೆ ಹೇಳಿಕೊಟ್ಟಿರ್ತಾರೆ. ಜೊತೆಗೆ ಸರ್ವೆ ನಂಬರ್ 393 4 ಬಿ 1 ಬಿ ರಲ್ಲಿ ಒಂದನೇ ವಾಸ್ತವ ಮನೆಯಲ್ಲಿ ತೆಂಗು ಮತ್ತು ಇತರ ಮರಗಳನ್ನು ಬೆಳೆಸಿರುತ್ತಾರೆ. ಶುದ್ಧಿಪಡಿಸುತ್ತಾರೆ. ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ಮಾಡಿ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬರ್ತದೆ. ಜೊತೆಗೆ ಸರ್ವೆ ನಂಬರ್ 393 4 ಬಿ 1 ಬಿ ರಲ್ಲಿ ಒಟ್ಟು 2 ಎಕರೆ 31 ಕೋಟಿ ಜಮೀನಿದೆ. ಒಂದನೇ ಎದುರದ ಕೇವಲ 0.56 ಎಕರೆ ಮಂಜೂರಾಗಿರ್ತದೆ. ಉಳಿದ ಜಮೀನಿದೆ. ಒಂದು ವೇಳೆ ರಿವಿಷನ್ ಜಮೀನು ಅರ್ಹರಾಗಿದ್ದರೆ ಸಂಬಂಧಪಟ್ಟ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿ ಅರ್ಹರಾಗಿರುತ್ತಾರೆ ಹೊರತು ಒಂದನೇ ಮಂಜೂರಾಗಿರುವ ಜಮೀನು ತನಗೆ ಮಂಜೂರು ಮಾಡಿ ಅಂತ ಕೇಳಬಾರದು. ಅದೇ ಅಲ್ಲದೆ ಒಂದನೇ ಸಂಘ ಸೇರಿದಂತೆ ಅಂಗವಿಕಲರ ಪಕ್ಷ ಕಂಡು ಬರ್ತದೆ. ಜೊತೆಗೆ ಕರವಟವಾಡಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 481 ಬಿ 7ರಲ್ಲಿ ಮಂಜೂರಾಗಿರುವ ಜಮೀನು ಸರ್ಕಾರಕ್ಕೆ ವಾಪಸ್ ಬಿಟ್ಟುಕೊಂಡು ತಹಶೀಲ್ದಾರ್ ವಿಚಾರ ವರದಿಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗ ಕಂಡು ಬರ್ತದೆ. ಆದ್ದರಿಂದ ಒಂದನೇ ಮಂಜೂರು ಮಾಡಿದ ಜಮೀನು ಮಂಜೂರಾತಿ ಆದೇಶ ರದ್ದುಪಡಿಸಿ ಸದರಿ ಜಮೀನು ತನಗೆ ಮಂಜೂರು ಮಾಡಿರುವ ವಿಜ್ಞಾನ ಕೋರಿಕೆಯ ತಗಾದಲ್ಲಿ ಯಾವ ಸಿಸ್ಟಮ್ ಬದಲಾಗಿದ್ದ ಉದ್ದೇಶಗಳು ಮೇಲ್ನೋಟ ಕಂಡು ಬರ್ತದೆ. ಆದ್ದರಿಂದ ಜಿಲ್ಲಾಧಿಕಾರಿ ಮಾಡಿದ ಆದೇಶ ಕಾನೂನು ಪ್ರಕಾರ ಸರಿ ಇದೆ. ಸದರಿ ಆದೇಶದಲ್ಲಿ ಮಾನ್ಯ ಈ ನ್ಯಾಯಾಧಿಕರಣ ಹಸ್ತಕ್ಷೇಪ ಉಂಟು ಮಾಡಬಾರದು. ಆದ್ದರಿಂದ
You challenge the order of grant before the AC was dismissed, confirmed in DC. But then you raise the contention that it's got a second grant, therefore an inquiry was conducted. An inquiry was conducted. Thereafter it was found that out of the total extent, only 56 cents is granted, and they found that it is a scheduled caste and is a disabled person. There is an observation that is open for you to seek for grant of the remaining portion. Now, if you want to argue, I will hold that you are ineligible under 94B, and I'll close all your rights. After having lost this, you know the grant has been upheld in terms of eligibility.
And read it. 46 order of the assistant commissioner which discussed my case. Kindly look at the reason. 46.
Yes.
Second paragraph.
Typed copies at page 48. Mailman is there.
48 second paragraph.
Yes.
ಮೇಲ್ಮನೆ ವಿಳಂಬದ ಈ ಪ್ರತಿವಾದ ಲಿಖಿತ ಆದೇಶ ಹಾಗೂ ಆದೇಶ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿದೆ. ಮೇಲ್ಮನೆ ಪ್ರವಾಸಕ್ಕೆ ನಮೂನೆ 50 ಮತ್ತು 53ರಲ್ಲಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. ತನಿಖೆ ಹಂತದ ಈ ದಾಖಲೆ ಆದರೆ ಸೃಷ್ಟಿ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿದಂತೆ ಪ್ರತಿವಾದಿಗೆ ಮಂಜೂರಾದ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ ಹಾಗೂ ಮೇಲ್ಮನೆದಾರ ಮಂಜೂರಾದ ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ ಬೇರೆ ಆಗಿರುತ್ತದೆ. ಮೇಲ್ಮನೆ ವಿಳಂಬ ಸಕಾಲದಲ್ಲಿ ನೀಡಿರುವುದು. The application.
The KAT has gone into all this.
This aspect of
Your choice is yours, Sherry. If I were to pass an order, I will say that your second application could not be maintained because your first application was rejected. And you lose the right under 94B. If I do that, your remedy for getting the remaining extent goes. Your choice. ನಿಮ್ಗೇನೋ ಒಂದು ಚಾನ್ಸ್ ಸಿಗ್ಬೋದು. ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ I will foreclose all your options because your intention is he's constructed a house that is residing there. He is a disabled person. The authorities have found he's a disabled person belonging to scheduled caste, and only 56 cents is granted.
This is the report given by village.
I am sitting under 227. I will go by whatever the tribunal has said. I'll accept it. And you have been litigating from eons. Your only intention is to somehow get this land on one ground or the other. On merit, you lost before the ACDC. Then you raised this bogey about double grant. And that poor person said, I'm prepared to surrender the first grant if it's necessary. No, he has said that. And that is only how much was he granted? 41 cents.
Once his application is granted, which is what has going to hold against me, could be applicable to him also. Whether his application under 94B is maintainable when he has filed.
No, that is a different land.
Correct.
What was granted was different. Correct. Is there an eligibility under 94B for getting grant if some land is already granted? Only if is a insert.
If the application is filed, then it's a matter of which line.
If he is a sufficient holder, then the same eligibility under 94B also will be applicable. He was not a sufficient holder. He only had 41 cents.
How?
Then where is the question?
The application itself is not maintained.
Nade, I will hold. You are in trouble. ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. I'm only saying the consequences. Page. No, I don't want to kill your case at this stage by me recording a finding that your second application, because both the authorities seem to have given you a small window for the other portion of the land. If I were to say something against you.
I understand. That's my difficulty. I find it very difficult to talk to. This we call next week and just consult if he wants.
I'll call this next this Friday. By that time, get some instructions.
Please.
Friday. I don't want to kill all your options by my order because I'm a bit annoyed by your client because the intent appears to only to harass that particular person. That is the view that I'm carrying now. ಮನೆ ಇದೆ ಅಂತ ಫೈಂಡಿಂಗ್ ಇದೆ. ನೋಡಿ, ನೀವು ಯೋಚನೆ ಮಾಡಿ ಫ್ರೈಡೆ ಹಾಕೊಳ್ತೀನಿ. I have expressed my mind. I will simply say that you had no right to seek at all. I will not go into all the merits.
Just to see an
I don't like this approach of your client litigating like this for 56 cents of land.
No, it is not 56.
Yes.
It comes in between. That is there the problem.
ನೋಡಿ, ಯೋಚನೆ ಮಾಡಿ. Your choice. Friday. Next Wednesday. Ready and these got a copy. No. We'll file it today. Next Wednesday. I can't hear you. Next witness. In joint memo along with affidavit ಅಂದ್ರೆ ಏನು? Next witness. Next Wednesday. यार यार notice complete ಆಗಿಲ್ಲ ಅಂದ್ರೆ use respond number 4. What is the order MQ? appeal ಹಾಕೊಳ್ಳಿ KT ಗೆ ಹೆಂಗೆ ಅಲ್ಲ ಎಲ್ಲರ ಇಂಟ್ರೆಸ್ಟ್ ಮೇಂಟೈನಬಲ್. We will refuse to exercise our remedy discretion because there is statutory appeal provided. So, entry mod ಇರ್ತಾ ಇಲ್ಲಿ before 1:30. Next witness. Next sir, L and K na. From 7A. 7A. You are the landlord or the applicant?
I'm the landlord.
Where is the order of the Deputy Commissioner?
Findings from is that my lordship he was in possession earlier, and by obtaining an injunction order in the year 1990, he has been dispossessed. That is what the finding the Assistant Commissioner order says. He was dispossessed by obtaining an injunction order in the year 1990, and it has been leased for and mortgage has been created. Therefore, the land has been granted it tenant. Lordship is certainly the order of the lordship is not maintainable in view of the verdict of some court. Admittedly, my lordship, as on the date of 11/1997, is not in possession. Moreover, my lordship, my contention is this. The RTC of the year 1971-72, what there it is delayed by the respondent here in my lordship. It was claiming to be a delay. Wherein my lordship in the column number 9, Kamalama's the present petitioner name has been mentioned. Admittedly, my lordship, as on that day, that this Kamalama is not the owner. Her husband Mahadevappa was his owner. From the year 1976, the YM Mahadevappa's name has been husband of the petitioner name has been entered in the regular parts. Lordship, for the black RTC, they are colluding with the revenue authority and manual RTC has been created to the present respondent and claiming that 5-day promise of it.
So according to you, 1374, the column number 9 was blank.
Yes, my lordship.
ಆಯ್ತು. 12 ಅಲ್ಲಿ ಏನಿತ್ತು? What was there in? What was there in? ಅಲ್ಲ, what was there in column number 12?
Respondent name.
Tenant's name was shown.
Respondent name has been given to be entered.
Ah,
For claiming, first claiming is the tenant.
sorry.
Lordship, kindly see your page number, annexure G, and page number 56.
What is this?
Page number 56, my lordship.
Yes.
Lordship, kindly see at column number 9, Kamalama, and 71, 72, Veeranna, Chenna Baswadev. And column number 3, my lordship, 1 has been entered.
Who is this Veeranna bin Channabaswadev?
He is the present claiming to be a tenant, first respondent, my lordship.
So his name was there even according to this RTC.
Yes, my lordship.
And the other RTC that you mentioned.
My lordship, kindly see at page number 14, at annexure A.
Page?
14.
Yes.
Page 14, annexure A, my lordship.
This was of the year 76, 77.
77.
What about the earlier?
Earlier, my lordship, because of this entry by annexure G,
This is in respect of 71, 72. No?
yes, my lordship.
Where is that entry? Where is the RTC of that particular year?
My lordship, that is what got entered by the first respondent in the revenue records. Alluding with the revenue authority.
Lala. Column number 12 ಅಲ್ಲಂತೂ ವೀರಣ್ಣ ಬಿನ್ ಚನ್ನಬಸವದೇವರು ಅಂತ ಇತ್ತು.
ಹೌದು.
We will assume that column number 9 is manipulated.
Yes.
But the cultivators column indicated their position.
ಇಲ್ಲ, ಅವ್ರ ಪೊಸಿಷನ್ ಇರಲಿಲ್ಲ ಅಲ್ಲಿ. ಅವಾಗ ಇವ್ರು ಯಾವ ಆರ್ಟಿಸಿ ಕಲೆಕ್ಟ್ ಮಾಡಿಕೊಂಡಿಲ್ಲ. ಇದು 97, 98 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಈ ತರ ಎಂಟ್ರಿ ಮಾಡಿಸ್ತಾ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇದನ್ನ ಕಮಲಂ ಮುಂದೆ ಒಪ್ಕೊಳ್ತೀನಿ ಅಲ್ಲಿ ಖಾಲಿ ಇತ್ತು ಅಂತ. ಬಟ್ ಕಲ್ಟಿವೇಟರ್ಸ್ ಕಾಲಮ್ ಖಾಲಿ ಇತ್ತು. ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತೀರಾ ಅದನ್ನ?
That is what my inspection was. Even assuming that my lordship, Veerana's name was existing, my lordship, it is not considered after 1976-77, and the condition precedent, my lordship, as of the date of.
Who is this gentleman, Mahadevru? I am Mahadevru. Page number 14 ಅಲ್ಲಿ cultivators column.
That is my husband. The present, but he died. After his death, my lordship, the present petitioner.
So your name came, your husband's name came about in 78, 79, 76, 77.
77. Lordship, it was earlier Gurumallappa Kalamma, that is father-in-law. Father-in-law name
ಅಲ್ಲ, ವಿಭಾಗದ ಮೂಲಕ ಅಂತ ಬಂದಿದೆ. So on that basis the entry came about.
Entry has been continued.
As on the relevant date, the name of the tenant is shown.
Relevant date it is not
74.
1974.
His name is there.
Yes, my lordship, but it is not 1997. There is no. His name is not there. My name is there.
The finding of the assistant commissioner is
Assistant Commissioner finding, my lordship. There is an injunction order in the year 1990. Subsequently, my lordship, in the year 1990, there was an acquisition proceedings where, my lordship, the notification has been done in the name of my husband, and the compensation has been received by my husband. And also, subsequent to death of my husband, my lordship, I mortgaged the property in favor of some registered mortgage in favor of.
how much was acquired in survey number 721/1? ಎಷ್ಟು acquire ಆಗಿತ್ತು?
It is about 18 months.
18 months. So there were, even apart from the acquisition, there was certain land remaining.
Yes. Certain land is remaining. That land.
And the mortgage that remaining land after the,
Yes.
in favor of,
Registered mortgage
in favor of
in favor of one.
bank.
Yes. Yes.
All right. Usuratory mortgage or simple mortgage? All right. Then that does not indicate anything regarding possession. Then
As on 1/11/1997, first respondent is not in possession.
That is your best point.
Yes, ma'am.
Continue in position till the amendment.
Yes, ma'am. As on the date of amendment, he is not admitted, he is not.
Where is the finding that he was dispossessed? On what basis does he come to the conclusion that he was dispossessed?
There is a civil court injunction order is also.
Sri, on that basis, he has said that he has been dispossessed. ಹಿಂಗ್ ಆಗತ್ತೆ ಹೇಳಕ್ಕೆ.
Finding ಇದೆ.
ಫೈಂಡಿಂಗ್ ಅಲ್ಲ, ನೀವ್ ಹೇಳಿ ನಮ್ಗೆ.
RTC has standing in the name of.
RTC is a different thing. On the basis of an injunction granted in your favor, can it be concluded that he had been dispossessed?
No, that is not the finding of the. Both the authorities.
So your only argument is 1997, RTC does not stand in his name, and this finding is that he has been dispossessed.
Land acquisition document is in favor of the petitioner.
ನಿಮ್ಮ ಹೆಸರು ಇರಬೇಕಲ್ಲ, you are the owner, therefore you can only claim compensation.
ನಾನೇ ಇದೀನಲ್ಲ, 9 and 12 ಎರಡು ನಾನೇ ಇದ್ದೀನಿ. Since 1976 up to date, even till today, my name is.
Anything else to show that you were in possession apart from
There is an injunction, my lordship.
injunction bittu? Injunction bittu.
Finding is very clear, my lordship. I am in possession of the property. And also RTC standing in my name, my lordship. And also these other acquisition proceedings and lease mortgage, registered mortgage document is in my favor. There is no document to show that first respondent is continued the possession till 1987. But the group court judgment of this honorable court clearly shows that clearly says.
Please come to page 86, para 30 of the order of the KAT.
But it is not clear that the name of the first respondent herein appeared in graduator's column of the land in question, not only from 1970, 71, 34, 75, but also during the year 1984, 85, again from 1986 to 90. This is absolutely wrong. This is absolutely wrong. There is no such evidence.
So for the even for from 84, 85.
It appears from the 91, 92, his name is not appearing as cultivators of the land in question in column number 22. And whereas the name of the husband of the client is appearing in column number 22 and also column number 9, but there is no material on record to show that on what basis the name of the first respondent was deleted from the RTC after 91-92, and on what basis the name of the applicant was entered in the same column. It is a specific case of the applicant that on 22/12/1990, she herself along with the son of Kumara Market came to the supply out of the land in question in favor of CH-23 Swami and handed over the possession of the same. But the same mortgage transaction was not binding on the possession.
So even according to you, CH-23 Swami was in position from 1990.
1990.
Then how can your husband's name enter in the RTC? If you want to rely upon that,
Much earlier to 1990.
no, if you are saying that column number 12 indicates the actual cultivator, by your own conduct, 1990 you gave up possession in favor of CH-23 Swami. His name is not in the records. So on what basis, how can you rely upon such an entry?
It is the mistake of the revenue authorities.
The earlier one could also be a mistake.
That's not
ಅಲ್ಲ ನಿಮ್ ಯಜಮಾನ್ ಹೆಸರು ಇತ್ತಲ್ಲ, ಅದು ಮಿಸ್ಟೇಕ್ ಇರ್ಬೋದಲ್ಲ.
He is claiming that I am the tenant. It is the duty of the tenant to show that is as of the date of the 1/3/1974 until
Up to 74, even according to you, there's no dispute regarding his entry in 12-2.
It is a disputed entry.
You are only disputing column number 9. 12-2 you have never disputed.
12-2 also, we are absolutely saying that he is not at all a tenant. He is
Not at all a tenant.
at any point of time.
My question is, where have you said in the entire proceedings that the entry in column number 12.2 from 7071 to 7475 are fabricated. Where is your sourcing? Because you're only arguing on the column number 9. No, ಇಷ್ಟೊತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು 12 ಅಲ್ಲಿ ಖಾಲಿ ಇತ್ತು, ಕಮಲಮ್ಮ ಅಂತ ಬರ್ಕೊಂಡ್ಬಿಟ್ರು. ಕಮಲಮ್ಮ ಓನರೇ ಅಲ್ಲ.
show that is a manipulated RTC. Kamalama, as on that day, Kamalama was not at all a owner. Despite my lordship, ಈ ಬರ್ತಿದ್ರು 97 ಅಲ್ಲಿ ಮಾದೇವಪ್ಪ ಇರಲಿಲ್ಲ.
ಅದಕ್ಕೆ ನಾನು ಫಸ್ಟ್ ಕೇಳಿದ್ದು ಕಾಲಮ್ ನಂಬರ್ 9 ತೆಗೆದುಬಿಡೋಣ, we will ignore it. Column number, show me where you dispute. Of ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿರ್ತೀರ. ಅಲ್ಲಿ AC ಮುಂದೆ ಎಲ್ಲಿ ಹೇಳಿದಾರ? ಆಯ್ತು, KD ಎಲ್ಲಿ ಹೇಳಿದ್ರು? ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಹೇಳಿದಾರ ಎಲ್ಲಿ ಹೇಳಿದಾರ? ಓದಿ ಪರವಾಗಿಲ್ಲ. If you want, I'll get the RTC register, look at it and then confirm it. I'll get the RTC register. If I am satisfied that the original, in the original, there's no tampering, I will record a finding. Madla, get the RTC register. Run at AGA to secure the RTC register in respect of survey number 721/1 of Yaragamballi village, Kasba Hobli, Yalandur Taluk. Next Wednesday. I have told you, I warned you, if I find there's nothing wrong,
wrong in the orders of the judicial orders for action. We have the budgeting part.
it's 1 o'clock next Wednesday. Now I have 2 more password matters. I don't think they will reach. I'll take it up next Wednesday. I can't get a kind of password. ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳೋದು? ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ. He asked for time, you could have simply agreed. Next Wednesday. Intermodal should stand extended to the next day. Notice to R6 and R7 is deferred for this. Why did you make them a party then? You sought time to ascertain status of the application said to have been filed with the petition for regularization. Next Wednesday.
where an immediate was made on 31/5/2001. That was an attempt was made by filing an application to the AC in the year 2012 to get it 2011-12 to get it changed. Expiry order was passed by the AC saying that since there is no limitation of more than 50 plus, the petition is dismissed. There we did not contest the matter, it was an expiry order. Then a petition was filed before the DC. The DC felt that since the civil court order, there were proceedings before the civil court, and whether the order is in accordance with civil court or not, on that count, the order was settled. This is the background of the case. The case
In whose name was the Kata standing in the first place?
first it was in the name of one Basvaya.
Wait, MR number?
This was prior to all these complications.
There's no dispute about the RTC. When was it changed from Basvaya in whose favor?
No, there was a civil proceedings. OS came to be filed.
OS?
Came to be filed. In
Number?
OS number 788 of 89.
Filed by?
Filed by Ratnama and sisters.
That is Basvaya sisters.
Ratnama, Shantama, Gaurama.
They are sisters of Basvaya.
Yes, please.
For?
Pursuant for partition was filed. The same was decreed.
When? So the sisters were granted a share.
Yes, please. Then
Compromise or?
there were 5 people, 5 children. 4
What is-
sisters filed the suit. During the pendency of the suit, one of the parents transport herself as a defendant.
Okay. FDP what
So,
happened?
people continue.
FDP what happened? So 1/5 share was granted.
1/5
To the
share
plaintiffs.
each was granted.
What happened in the FDP?
FDP also, it was decreed on 11/10/2001.
Number?
28 of 9.
When was it agreed?
11/10/2001.
This survey number that we are concerned
There
with.
are 5 survey numbers in all cases. And I will come to this.
No, I just want these facts. In the final decree proceedings,
Yes.
which survey
But
numbers were?
before that, there was an RA. That is 1 of 94. That was the DD was on 23/1/2002.
That is against OS 788.
Yes, please.
RA,
1 of 94.
what happened?
This was the. That was on 23/1/2002.
No RSA.
RSA was filed 3/27 of 2002.
2000?
2.
What happened?
This was on 10/12/2007.
Then?
10/12/2007.
No SL.
This is the civil code. As far as the civil code is concerned, this is what has happened.
In the FDP, what was granted to you?
1/5 share each.
That is the preliminary decree, it was declared.
That is all. That's
In
all.
the final decree, which survey number was divided?
Nothing of that sort happened at all.
And how can the final
The
decree?
sisters continue to be joined. RTC continue to be joined in the 3 weeks. 3 sisters weeks.
When did the name of these sisters come about in the revenue
In the
records?
year 97 weeks.
On what basis?
Because
Because the suit was declared
suit
only
was decreed after that, the revenue entities were changed to the name of the sisters.
by MR.
In my 97,
83 decree 97 ಅಲ್ಲ ಆಯ್ತಾ?
83 years, 90,
No, you said 93 now. 11/11/93.
Actually, MR number 11 of 96/97. All the sisters names have come.
Okay. No, that I can understand, but in the FDP, there should be a clear division.
There is nothing of that sort that has taken place.
Then how do you resolve this issue?
May I please you? Meanwhile, the 3 sisters did not have any dispute amongst themselves. One of the sisters made an application to transfer the property to one of the sisters, that is Ratnama's name, who is the petitioner before your lordship.
Among the 3 sisters.
Yes, please.
So among the plaintiffs,
There
one,
is no dispute as on that.
so you ignored the final decree and sought for a change of kata on the basis of your own
Yes,
consent.
please. And form number, according to as per form
2020, the name of Ratnama came into records. Just from the AC's order and the order that they have filed, the other sisters gave no objection to that.
But the brother and the defendant sister.
They are not in the only the dispute.
No, but on since the artist is to the name of Basvaya, on the decree of the suit, both Basvaya and his 4 sisters got a share.
Yes, please.
So once one of the plaintiffs make an application for change of kata, necessarily the brother and the other sister should also be heard in the matter.
Yes, please. Your Honor. And what has happened is these 3 sisters only the dispute is among these 3.
So you ignored them completely.
No, please. These 3 sisters made an application, got the kata changed to their name in the year 31, that is on 31/12/2001, please.
31/3/2000.
During the pendency.
Even
of all
before the
proceedings, only this has happened.
Atta, in respect of 3 Ratnamma,
Yes, please.
on consent
Yes, please.
by the other 2 sisters.
Yes, please. Then there was a gift deed and sale deed. There were 2 sale deeds and 1 gift deed.
From Ratnamma.
Ratnama and all the sisters. They sold 2 properties.
Gifted, who gave it?
I'm telling about the sale deed.
Sale it is first or gifted is first?
First is sale deed.
Date?
Apparently, 1 year is from 8/1/2012.
Ratnamma and other 2 sisters together.
Their family member. But there is only these 3 sisters.
3 sisters sold.
Sold the property
To whom?
to some third party. And in the sale deed also, they have accepted the RTC is in the name of Ratnama. The sale deed is made. After 4 months, the other 2 properties which are remaining, I will not have the other one more property as to what has happened. 2 properties were changed to the was gifted by Ratnama in favor of her daughter. That is the second petitioner before the court.
Ratnamma gift to second petitioner. When was this? When was this date?
This was on 7/5/2011.
So
After
though,
4 months after the sale.
so though you had only 1/5 share,
Yes, please.
the 3 sisters,
Yes, please.
you decided to sell the land to a third party.
Yes, please.
Then again, you gifted the property to your second,
There are 2 properties were gifted.
but you only had 1/5 share in all of them.
There is no dispute between the other 2 persons, why they did not pay, whether they have taken, there is nothing with regard to that of the record. Then after all this, on 7/5/2011, there is a gift made. After that, they come before the case saying that
Who comes with this?
the other 2 sisters, please. One Gaurama is dead by now. The children of Gaurama and Shantama come before the AC saying that this is not in accordance with the civil court order.
So they challenge the sale to which they are parties.
They are not challenging the civil court.
No, they're challenging the mutation made pursuant to the sale deed to which they are parties. So that they cannot do.
That is what the AC has held. That was assigned to the AC. AC said it has to be done in accordance with the AC. That is the reason why I am.
Don't you think DC is right? Ultimately, all of you are bound by the FDP.
Yes, please.
Now you ignore the FDP and then go by your own independent way of dealing with the properties. Then how should the decree be respected?
So, Lordship, can we see what has happened is all the 3 sisters have come to the conclusion that because of their family necessities.
No. Can the sisters ignore the final decree proceedings?
All the 3 of them got a share. Only the Tata was transferred.
As far as revenue authorities are concerned,
Yes, please.
they'll have to enter the names as per the final decree proceedings.
Yes, please.
If you, like you, all of you together sold the property to somebody, that is fine. The purchaser will take care of his problem. The other properties which are not conveyed by all of you together,
Yes, please.
they will have to be by the final decree only.
Your Lordship, can we see the final decree also there was no separate share allowed.
Whatever is there in the final decree, it's right or wrong,
Yes, please.
they'll have to follow
Yes,
it.
please. Now, the question is whether the gift deed executed is right or wrong, whether it is a registered gift, and it is a registered gift. I have the submission before the court. Since it is a registered gift, whatever are the civil rights, there is already a suit filed before the court of Madhya
By whom?
challenging the gift deed by these other 2 sisters. So that will take the place because the AC entry was made in the year 2011.
But I am of the view that the entry should first reflect FDP. If that has not been done, all other transactions, ignoring the FDP is wrong.
Nobody made a petition till date.
We are not concerned about your interests or rights. They are the revenue authorities.
Yes, please.
They will not sit in judgment over what the civil court has done. They will not permit you to ignore the decrees obtained by the civil court and act independently. They will go by the decree. Whatever has happened thereafter, you guys are in the civil court, enjoy. But the entry should reflect the FDP.
Can you see that the FTP proceedings has taken place way back in the year 2001? This 2001 only, after the FTP proceedings, mutation entry was made on 31/5/2001.
No, you said it was pursuant. You said it was pursuant to the preliminary decree. On 11/11/93, you said there's a preliminary decree. On that basis, it has been changed.
I know that has been done with regard to revenue records. As far as mutation entry, which they have challenged now is 31/12/2001.
That is this sale deed and the gift deed.
Not the sale deed, it is only transferring it to one name. The usual name of Ratnamma, they gave a consent. That was in the year 2001. I repeat.
No, you skipped a step because you told me FDP was passed on 11/10/2001.
Yes. Prior to that, after the preliminary decree that is on 11/11/19, the entries in the revenue came in the year 1997. All the sisters, three sisters made along with the brother and Manu, that is other sister, was also found in the year 1997.
Then you told me on 31/3/2001, the other two sisters gave consent for change of khata
31/2001.
in favor of Ratnamma. Accordingly, the revenue entries were changed.
Yes.
The problem with this is the sisters
That
could
also
not.
took place after the FTP. That took place after the FTP proceedings.
Could that have been done in the light of the FDP?
They said there is an oral partition and.
Could that have been done? Could the civil authority, could the revenue authorities ignore the FDP, assuming that they given?
All the three names, but there is nothing to show.
That is not the point. There is a final decree obtained. You gave up the final decree and you went and said, now ignore the FDP. There's no oral partition. Go by the oral partition.
It's not like that. There was a final decree proceeding, rights to the parties between the brothers. There was a challenge that the brother did not give me the property, so we further challenged the order that brother defied the suit for partition. The suit for partition was declared and it is attained and active in the court process. There, even in the initial stages and thereafter also, three joint shares on a period, 1/5 share each was the order made by the trial court, FTP proceedings, and the other two proceedings were only dismissed. So it is made three together head the path. That is the RTC stood and all the sisters, three sisters made. After that, they came to an arrangement that they let the Tata start in one name and they gave no objection to transfer the name to one of the sisters. They acted on that by selling the property. And then after 10 years, they come before the AC saying that that order which entry which is made is not in accordance with the proceedings. My humble submission before the court is, when they wanted, they have acted in one form. And after sale of the property, which they have taken the whatever is the amount they got from the safety, it was understood that one, two of those sisters would take. That is the understanding. Because one of the sisters' daughter had to be married, it was in a hurry, so the property was sold. These are all the internal arrangements. Nothing is on record. After that, only after two sale deeds were executed, when the remaining two properties were gifted to the daughter, this has come up with the book. My humble submission.
So according to them, you took advantage of their consent to appropriate the property to your daughter.
Even assuming
That appears to be the case.
assuming that I have done that, that I have done something like that, then they challenge the guilt, it is pending before the civil court. So why should the 10 years back revenue records which have been changed in the name of Ratnamma should be changed now without any basis?
That is because of the final decree, it's got to be changed. You just now made a submission that they cannot at one time give consent and thereafter withdraw the filing an appeal. The same argument will hold good for you also. You went to the court for a preliminary decree, got a preliminary decree and a final decree. you cannot wish away that final decree in the absence of the defendants.
It is not done. It is all the three sisters' name are already found in the revenue records.
That is only on the basis of the preliminary decree. The Kata stood initially in the name of Basvaya. Because you obtained a preliminary decree, the entry came about in the RTC.
Yes, please.
It is followed by a final decree.
Yes, please.
Final decree is not reflected in the RTC.
Final decree proceedings.
All the three sisters ignored the FTP and said, no, don't forget about the FTP. Let the Kata be in favor of Ratnama.
Page number 24, please. Right copy of the matter.
Has this been reflected in the revenue records?
No, please. But the names of the sisters were already entered. Your lordship may kindly see. The suit coming on second paragraph. It is ordered and decreed that the suit of the plaintiff is decreed against the defendant, declaring
Even the name of the defendants are to be entered in the revenue records as per this.
the defendant's name also existed, please, Your Lordship. Only these three.
If that is so, if the name of all the parties entered in the revenue records, on what basis did Ratnama's name alone be there? On the basis of two sisters.
Those two sisters, the sisters gave the consent to change the name.
What about the brother and the other sister?
I am not aware of what has happened to their share, please, Your Lordship. Whether they have taken a different share or whether only 1/5 share is conveyed, I am not aware of that, please, Your Lordship.
You obtained a decree in which 1/5 share is granted to everybody, isn't it?
Yes, please.
So they also have a right in the.
Yes, please, Your Lordship.
Then the Kata on the basis of the consent of just two of the plaintiffs. In the absence of defendants,
Your Lordship, may kindly see the other two persons. They did not give consent also. So nothing.
so therefore even on that score the mutation is bad. Mutation should reflect the final decree. Thereafter you may do whatever you want.
Your Lordship, may kindly see. It was by the decree itself, so they reflect on the basis.
So your basic argument is I can ignore the final decree because
No, please, Your Lordship. No, please, Your Lordship. I am not asking the court to ignore the in the final decree also, what has happened, what is stated, has already taken place before the final decree. It is ordered and decreed that the suit for the plaintiff is decreed against the defendant.
all right, madam, I'll put this question to you and close this. There were three sisters granted 1/5 share.
Yes,
If two sisters were to relinquish their share, on what basis can it be done?
they have not relinquished their share, please.
The consent that is granted.
It is only the RTC names to be changed. That is all is what is stated.
The Kata can be changed only on the basis of registered instrument or by way of succession. Is there a registered instrument in your favor whereby the two sisters relinquish their share in your favor?
Lordship, may kindly see. It is not the copy. It is identified by the Kata is not the right of the parties. It is only the name of to be reflected in the record. Here, they have said the Kata be style, let the Kata be in my system. That's all. That is all. Nothing else is stated. I will take your lordship to that revenue entry also, please. It is at page PE2, please. Type of
Page?
Other side. It's a type copy.
Yes.
Kata number are so and so Veeravataya, Shatamma, Konsidaran, Disability, Senti, Apigo. ಇವರ ಕೊಡು ಕಾಸ ಹಾಕದ ನೀರಾಗಿದ್ದು ಇವರ ಪೈಕಿ ರತ್ನಮ್ಮ ರೇವಣ್ಣ ನವರ ಇಬ್ಬರು ಹೆಸರಿಗೆ ಉಳಿಕೆ ತಂಗಿಯರಾದ ಗೌರಮ್ಮ ಹಾಗೂ ಶಾಂತಮ್ಮ ನವರು ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡಲು ಫಾರಂ ನಂಬರ್ 20ರಲ್ಲಿ ಒಪ್ಪಿಗೆ ಕೊಟ್ಟಿದ್ದು ಒಪ್ಪಿಗೆ ಖಾತಾ ಬದಲಾವಣೆ ವಿಚಾರವನ್ನು ಗ್ರಾಮದಲ್ಲಿ ಮುಖ್ಯ ಮತದಾರರು 2021ರಲ್ಲಿ ದಿನಾಂಕ 25/11/2001ರಿಂದ 30 ದಿನಗಳ ಕಾಲ ಪ್ರಚಾರಪಡಿಸಿ ಈ ಬಗ್ಗೆ ಯಾವುದೇ ತಕರಾರು ಮುದ್ರಿತ ಅವಕಾಶ ಒಪ್ಪಿಗೆಯಂತೆ ಆರ್ಡರ್ ತಡೆಯಾಗುತ್ತದೆ. ತಂಗಿಯ ಒಪ್ಪಿಗೆಯಂತೆ ಖಾಸಾ ಅಕ್ರಮ ರತ್ನಮ್ಮನ ಹೋಮ್ ಸಂಸ್ಥರ ಅವರ ಹೆಸರಿಗೆ ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡಲು ಆದೇಶಿಸುತ್ತದೆ. Only the name of the party was changed as on the consent of the sisters.
So by the same argument, the moment they say I am revoking my consent, the entry should go. By consent it can be made. The consent can be revoked also. I withdraw my consent, therefore revoke this.
That there should be a procedure which has to be followed if at all they have to.
That is why I said if there's a registered instrument, yes. Today they gave consent, tomorrow they revoke the consent. If your argument is accepted, it's only revenue entry, it can be done by consent. It can also be withdrawn by consent.
My lord, by the time this entry was challenged, there's also a registered document.
That is either way, civil court will take care of it, whether you had a right to execute the gift deed or not.
My name is also there in the RTC, no, please.
To the extent of 1/5 share as per the final decree, it will continue. That is all.
Your Lordship, there are two things. Unless petitioner number 1 got the right by way of the final decree. Petitioner number 2 has got the right by way of registered giftee. My name is found in the RTC as per the registered giftee, not as per the RTC. I got my name mutated as per the registered giftee. Once my name is mutated as per the registered giftee, unless the giftee is cancelled, any authorities do not have the authority to cancel this.
You're right if you were to say that it is pursuant to the final decree. The entries were made and thereafter is gifted, rightly or wrongly, it is one thing. If the final decree was not given effect to at all, and the name of the defendants therein was also not included, your entire argument falls to the ground. Then you should not be aggrieved. 1/5 share is it will reflect.
But after it's a registered giftee, that is also being challenged. I think that the authorities do not have the right to look into that. One
I will make it clear that the entries would abide by the result of that suit. Until then, it will reflect the final decree proceedings.
If that is done, there are two statements of which are already being executed.
That will be also subject to the suit. If there's already a sale by all of you, there's no dispute. If all the three sisters. But the problem is sale is executed by all the three sisters.
Whatever it is, please, Your Lordship, the revenue entities will have to.
You're not holding wakalat for the purchaser. You're also a party to the sale.
Yes, please.
So I will record your statement that you have no objection for the change of kata and rest of the property to which you are a party to the sale deed. Don't worry, one sale deed which you are a party. I will record your statement that the kata can be changed on the basis of your concession before me, that you agree with the sale deed and the kata be changed in accordance with the sale deed. They are also parties to the sale deed. Automatically that will be given effect to. We are concerned with that properties which are not subjected to sale and which are ordered to be shared amongst all the persons. So I will record this statement also. I will protect that purchaser. Don't worry. Same consent.
ಸುಮಾರು 15 ವರ್ಷಗಳ ನಂತರ ಸದರಿ ಖಾತೆ ಆದೇಶವನ್ನು ಪ್ರಶ್ನಿಸಲಿಕ್ಕೆ ಮೇಲ್ಮನವಿಗಾರರು ಯಾವುದೇ ಸಕಾರಣವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. If at all a revenue authority will have to entertain a revenue petition, then the delay will have to be explained.
For 136(3), delay is not necessary. If the deputy commissioner sees that the entries made in the records are irregular and are without any basis, suo motu can pass an order. He doesn't have to wait for the procedure. If he feels an entry of X on the basis of some consent is wrong, if the actions were registered, he can pass an order. All that he has said is go according to the final decree proceedings.
Yes, please. The order is filed by the
one petition, the period in the paragraph 6. The result of the period is other period was an oral partition between the first petitioner and the fourth respondent, and mother of the respondent was identified. But she was in Orama and Rosa at the oral partition. The land registrar number 35 was to measure 20 Uttar and land registrar number 2 measure 70 Uttar, excluding the share of the Saswaya, 1/5 share, was not allotted to the share of first petitioner, and according to the there is their own reading the oral partition. Now he is submitting that there is I have given a consent. Their own reading is not.
There is a document which says it has been given by consent.
Come at 2:30, I'll dictate orders. 2:30. ನೀವು ಕನ್ಸೆಂಟ್ ಕೊಡಬಾರ್ದಾಗಿತ್ತು. ನೀವು ಚೆನ್ನಾಗಿದ್ರಿ ಅವಾಗ ಕೊಟ್ರೆ ಕನ್ಸೆಂಟ್. Others I'll repeat next Wednesday. Number 44. 2:30.
Serial number 44, interim order may kindly be extended.
Interim order will extend. 30? Sir. 21st. 21st. Interim orders and all the other matters, if it is there, it will be extended.
58, my lord.
39.
58, my lord. From the last 4 weeks, it's coming but not reaching, my lord.
What can I do? Whether I take
Maybe
up old
here at
matters or I take up
2:30.
new matters.
2:30 matter, mandamus, writ of mandamus, my lord.
If you want come at 4:45, get the other side. After 4:45, I'll take it up. If the other side agrees.
Other side government, my lord. Only our government.
If they agree, come at 4:45.
Much obliged.
ಅವರು ಅದನ್ನ ಹೇಳಿದ್ರು. I am concentrating on the old matters. First 52. Next Wednesday.
So before the Form 7, it is not the other course now not Form 7A. If it is a Form 7A, I have to go before the.
Then what is the order? What is the order passed? What is the order passed by the Assistant Commissioner?
The authorities on Form 7, treating that it is a Form 7. Sir, can you see the annex 38?
How can he entertain a form number 7?
Only one thing. Can you see the order? Can you see the annex page number 13? First, ಪ್ರಸ್ತಾವನೆ ಇದು ಲಕ್ಷಣ can you see that? ಅರ್ಜಿದಾರರ ಅಂಜನಪ್ಪನವರು ಸತೀಶ್ ಬೇಗಳೆಯವರು ತುಮಕೂರು ಜಿಲ್ಲೆ.
No, how can he file a form number 7 in 1989?
That is the question. Will not be a limited period. Will not is already within period. Therefore, I filed application is a Form 7A. My case is not a Form 7. I filed. The authority is treated as a Form 7 and rejected. Therefore, the DC has no jurisdiction. It has to go before remanded to Assistant Commissioner Land Tribunal.
It is
they
your,
have to decide. You must whether
no,
it is a 7 or 7A.
It is your case. It is 7A.
7A.
I will record the statement and ask you to go prepare an appeal. I will hold that according to you, this order is passed wrongly by constituting as form number 7, though the petition contains its form number 7A. Because it contains form number 7A, an appeal is maintained.
If it is a 7A, then not only appeal.
You are saying it is 7A.
7 absolutely. My application itself is 7A.
Then I'll make that sure.
Not considered. Therefore,
I will direct the CA to consider that, saying that you had filed a form number 7. The Assistant Commissioner, by the impugned order, has rejected the application filed by the petitioner by construing the application to be filed under Form 7. Next paragraph. Learned counsel for the petitioner contends that the petitioners had actually filed form number 7A under section 77 capital A of the Land Revenue Act of the Land Reforms Act. But the Assistant Commissioner has wrongly construed the application. Additional DC has wrongly considered the application as an application in Form 7. Next paragraph. Since the petitioner contends that the application that he had filed was under section 77 capital A, that is Form 7A, he would be entitled to challenge this order by filing an appeal. So accordingly, reserving liberty to the petitioner to prefer an appeal against impugned order, this writ petition is dismissed. Next paragraph. The tribunal shall take note of this contention of the petitioner that he had actually filed a form number 7A and not form number 7 and entertain the appeal on merits. The petitioner is granted 3 weeks to prefer an appeal, 3 weeks from today to prefer an appeal to the current appellate tribunal. Registered to return his certified copy after returning a copy of court records.
Court officer serial number 55 ಏನ ಡೇಟ್ ಕೊಡ್ಬೋದಾ? Court officer ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೋದಾ? ಈಗ ಯಾವತ್ತಿರುತ್ತೆ?
Second list serial number 2 ಏನಾಯ್ತು ಸರ್? ಹಲೋ ಸರ್, ಕೇಳ್ತಾ ಇಲ್ಲ ಮೇಡಮ್, ಪ್ಲೀಸ್. ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಏನಾಯ್ತು ಸರ್?
ಆಫೀಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇಲ್ಲ.
ಆಫೀಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸರ್. ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದಾರಾ?
ಇದೇ ಮಾಡ್ಕೊಡ್ತೀವಿ ಚೇಂಜ್ ಮಾಡಿಸ್ತೀವಿ ಹೋಗ್ತೀರಾ ಆಮೇಲೆ
Court officer, sir. Court officer, sir.
During the fourth pillar, the segment between the picture and the quarter whose statistic component mediated equation.
In order, no?
Order begins the order of the coding of the fact that
Who's for the respondent?
it is not both respondent, fifth or sixth of the practice. 5 and 6 are only one per party.
Earlier, let us see.
So both respondents.
Earlier, I'll call it.
I will intimate another polygon.
Earlier, I'll ask her.
Serial number 4, my lords. List 2.
Yes.
I'm for the respondent. I appear for the respondent, my lord.
Which respondent?
Respondent number 4, my lords. My lords, the matter may be taken to mediation, my lords. Matter is almost settled. Matter
There's
may
no
be taken up for
number
mediation.
4. Who's for R5 and R6?
My lords,
Either you settle it here or you'll I'll dispose it off. Mediation hogotu barodu 2013. Ile ಮಾತಾಡಿ next week ಹಾಕೊಳ್ತೀನಿ next week ಮುಗಿಸಿ. Next Wednesday. Next Wednesday ನೀವು ಕರ್ಸಿ ಮಾಡಿ. Thursday. 24th. ನೀವು ಇಲ್ಲ ಮದುವೆದ ಕಾರಣ ಹೇಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಅದಕ್ಕೆ ಅಕಾಮಿಡೇಟ್ ಮಾಡಿ 24th ಆಗ್ತಾ ಇದ್ದೀನಿ. 24th ಮಾಸ್ಟರ್ ಮುಗಿಸ್ಕೊಡು. ಅದಕ್ಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊಬಿಡಿ, ನಾನು ಡಿಸೈಡ್ ಮಾಡ್ತೀನಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಮಾತಾಡ್ತೀನಿ ಇರಲ್ಲ ದಯಾಲ್ ಅವರ. Next Friday. 24th. 27th. ಒಂದ್ರ ಮೇಲೆ 5 ನಿಮಿಷ ತಗೊಂಡಿದೆ ಬರೀ ಒಂದು ಡೇಟ್. 28. 29 of when counsel for the petitioner writes a memo seeking for permission to withdraw the petition. Memo is accepted. Petition is dismissed as withdrawn. Retirement and withdrawal. Seeking and filing a memo for retirement. Counsel for the petitioner has filed a memo seeking for permission to retire. Along with the memo, he is also furnished is also enclosed a copy of the retirement notice and also the postal track sheet showing that, which indicates that the notice was delivered. In view of the above, the petitioner, counsel for petitioner is permitted to retire. So since there is no representation on behalf of the petitioner, petition is dismissed on non-prosecution. 20 of I will allow the application.
No, abatement.
They
I
offer-
have not served a copy to the other side. And also, abatement application is not there.
I'll allow it. I'll set aside the other. You be here, I'll
And 1 week,
ಏನಕ್ಕೆ I'll take it up to
then I will not take time. That's why not.
next Wednesday.
You not allowed.
On next Wednesday, I'll allow.
Then I will not make abatement. I will make my abatement.
2012 ಇಲ್ಲ ನೋಡೋಣ.
In this case, I represent the respondents.
ನೀವ್ ಯಾರಿಗೆ ನೋಡ್ರಿ?
ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಏನೋ ತರಿಸಬೇಕು ಅಂತ ಅವನ್ನೇ ಡೈರೆಕ್ಟ್
ಬಂದಿದೆ, ರೆಕಾರ್ಡ್ ಬಂದಿದೆ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಫೈನಲಿ. Yes, madam. Yes. No, suo moto, yes. But in a revision petition is filed before him. If he notices an irregularity, even then he can do it.
As far as AC's order is concerned, the AC's order is clear that only because he has not discussed anything on rights in the case, he has opinion delays and no explanation to the delay is given. And moreover, there is already a that is a registered document as a second. Is the as of now. Because the revenue authorities cannot look beyond the registered document. On that count, the AC has dismissed the petition. Though we were expired, he had not appeared to the AC. And before the DC had that, he did not discuss anything with regard to limitation. He did not discuss the order, which is the input order, which is challenged. Now, if the AC's order is taken, there is no mistake to be found as per the AC order is concerned because there is 15 years delay on limitation, right? And the AC cannot go beyond that is a second position of the limitation. And the and registered document policy that exists in the registered document, even then the AC cannot go beyond, or any area authorities for that matter cannot go beyond the registered document. These two are separate positions of law. And there is no mistake in the AC order, wherein the DC can set aside the order based on the mistake committed or some illegality as far as the AC is concerned. Then under 136(3), if the DC will have to take up the matter, it is just form of the proceeding. These two decisions are passed on. That is, it should be within a reasonable period of time. That there was a delay of 55 years and also. Here there is a delay of 90 years from the date of the order. So there is a delay, and soon also period, which will have to be reviewed. They have discussed with regard to the third-party interest or rights created also in this 2015. That is, in fact, I have not gone through the entire decision, and I will just not time to make the decisions. Legal exercise of provision and restriction is frowned upon because the actions. This is also a revision petition that DC set us in the order. Legal exercise of provision and restriction is frowned upon because if actions of transaction or transactions were to remain forever open to the challenge, it will be avoidable and endless uncertainty to human affairs, which is not the policy of law. Because even when there is no period limitation is spent for exercise of such purpose, the ensuing delay may have led to creation of third-party rights that cannot be trampled by the related exercise of the discretionary power, especially when no cogent explanation for the delay is in sight. Full of experience must run closely with the rule of life. Even in cases where the orders of the rights of fraudulent, the exercise of the power must be given a reasonable period for the discovery of the fraud. Simply describing an act or transaction to be fraudulent will not extend the time for its correction to infinity, or otherwise the exercise of judicial powers would itself be tantamount to a fraud upon the statute that rests upon the power in an authority. My humble submission before the court is these regular entries took place way back in the year 2019. FD proceedings also took place much earlier, and in the year 2001-2002, till the appeal was filed, that is the AC. No, where they have raised the objections. Only after a sale deed was executed, and after that the gift deed was executed, after the death of one of the sisters, that is Gaurama, she expired. After the death of one of the sisters, the children, along with another aunt, had raised the petition, filed the petition before the ACPG, questioning the illegal entry of 2001-2002. That is the reason why the AC said there is a 15 years period of delay, and it cannot be set aside. More so, by then, all the pre-registered back my total submission. First round.
ಇನ್ನೇನಾರು ಇದೆಯಾ?
In page number 19.
90.
It is on the 23/8/2001.
Decree is dated 99.
ಆಗಿದೆ ಬಟ್ ಕಾಂಪೇಪರ್ನಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡಿರೋದು ಮೇಲೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಾಂಪೇಪರ್ ವಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಇಸ್ 23/8/2001. But it all of the campaign was from one Ratnama, Gaurama, and after this it is taken. The mutation was affected. Page number 62. It is typed from.
Page?
Page 62. 61 is the 62 is the typed from.
Yes.
ಅದರಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ದಿನಾಂಕ 25/11/2001 ಪ್ರಚಾರಪಡಿಸಲಾಗಿದೆ. ಅದಕ್ಕಿಂತ ಮೊದಲು ಇವರು ಡಿಟಿ ಖಾತೆಯಲ್ಲಿ ನನಗೆ ನೋಟ್ ಹೇಳೋದು ಅಂತ ಹೇಳ್ತಾರೆ. How can it pass? Final decree is taken by all three sisters, including the petitioner also. Petitioner also is one of the party to the final decree. We obtain the final decree in the sample.
Where is your appeal memo? What was your contention before the AC? AC order is there?
AC order is there. AC ಏನು ಬರ್ತಿಲ್ಲ. AC order passing page number 70 last annexure. Is that AC I have taken specific contention in the last paragraph is here. ಪ್ರಸ್ತುತ ಸತ್ತುಗಳು ಒಂದನೇ ಅರ್ಜಿದಾರರಾದ ತಂದೆಯಾದ ಬಸವಲಿಂಗಪ್ಪ ಅವರ ಪುತ್ರನಿಂದ ಆಸ್ತಿಗಳಾಗಿದ್ದು ಬಸವಲಿಂಗಪ್ಪನವರಿಗೆ ಬಸವರಾಜು, ರತ್ನಮ್ಮ, ನಾಗಮ್ಮ, ಗೌರಮ್ಮ ಮತ್ತು ಶಾಂತಪ್ಪ ಎಂಬ 5 ಜನ ಮಕ್ಕಳು. ಅವರುಗಳ ಪೈಕಿ 2 ಮತ್ತು 3ನೇ ಅರ್ಜಿದಾರರ ತಾಯಿಯಾದ ಗೌರಮ್ಮ 2002ರಲ್ಲಿ ಪೌತಿಯಾಗಿರುತ್ತಾರೆ. 1 ಮತ್ತು 3ನೇ ಅರ್ಜಿದಾರರ ತಾಯಿಯಾದ ಗೌರಮ್ಮ ಮತ್ತು 1ನೇ ಅರ್ಜಿದಾರರ ತಂದೆ ಭಾಗಾಂಶ ಹಾಗೂ ಪತ್ರಿಕ ಸ್ವಾಧೀನವನ್ನು ಕೋರಿ ಬಸವರಾಜ ಹಾಗೂ ನಾಗಮ್ಮ ಅವರ ವಿರುದ್ಧ ಮಂಡ್ಯ ಪ್ರಧಾನ ನ್ಯಾಯಾಲಯ ಹಿರಿಯ ವಿಭಾಗ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಸಿರು ದಾವ ಸಂಖ್ಯೆ 788/89 ಪ್ರಕರಣ ನಡೆದು ಭಾಗಾಂಶ ನೀಡಿ ತೀರ್ಮಾನವಾಗಿರುತ್ತದೆ. ನಂತರ ಗೌರಮ್ಮ ಅವರು ಡಿಗ್ರಿ ಅನುಸಾರ FDP 28/94 ಡಿಗ್ರಿ ಅನುಸಾರ ವಿವಾದಿತ ಸ್ವಾಧೀನ ಪಡೆದುಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಾರೆ. 3ನೇ ಎದುರುದಾರರು 1ನೇ ಎದುರುದಾರರ ಹೆಸರಿಗೆ MR ನಂಬರ್ 22/2001 ದೃಢೀಕರಿಸುವ ಮೊದಲು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿದ 1ನೇ ಎದುರುದಾರರ ಹೆಸರಿಗೆ ಯಾವುದೇ ಹಕ್ಕು ಇಲ್ಲದಿದ್ದರೂ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಭಾಗಾಂಶ ಹಕ್ಕು ಮಾತ್ರ ಇತ್ತು. ಪ್ರಸ್ತುತ ಆದೇಶವು ಕಾನೂನಿನ ವಿರುದ್ಧವಾಗಿತ್ತು ಎಂದು Here, there is specific allegation made against changing of the contract. And the passing the order by the AC concluding that in the 2022 ಆಗಿದೆ. 10 ವರ್ಷ 15 ವರ್ಷ ಸುಮಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಆ ಕಾರಣದಿಂದ ನೆಕ್ಸ್ಟ್ ಮಾಡ್ತಾರೆ. But considering this, I filed the revision petition. Deputy Commissioner has appreciated.
Did you dispute the consent?
No, I am not given a consent.
No. Where have you said in the Assistant Commissioner that you did not give consent and the order was passed in?
FTP in page number 71 7th line. FTP 28/94 ಡಿಗ್ರಿ ಅನುಸಾರ ವಿವಾದಿತ ಸ್ವತ್ತು ಸ್ವಾಧೀನ ಪಡೆದುಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದಾರೆ. 3ನೇ ಎದುರುದಾರರು 1ನೇ ಎದುರುದಾರರಿಗೆ MR ನಂಬರ್ 22/1/2002 ಅಂಗೀಕರಿಸುವ ಮೊದಲು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸದೆ 1ನೇ ಎದುರುದಾರರ ಹೆಸರಿಗೆ ಯಾವುದೇ ಹಕ್ಕು ಇಲ್ಲದಿದ್ದರೂ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಿಂದ ಭಾಗಾಂಶ ಹಕ್ಕು ಮಾತ್ರ ಇತ್ತು. ಪ್ರಸ್ತುತ ಆದೇಶವು ಕಾನೂನಿನ ವಿರುದ್ಧವಾಗಿರುತ್ತದೆ.
ಅಲ್ಲ, ಬೇರೆ have you said ನಾನು ಒಪ್ಪಿಗೆನೆ ಕೊಟ್ಟಿರಲಿಲ್ಲ ಹಂಗೆ ಮಾಡಿದಾನೆ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
I am calling that I am not given ನಾನು ಒಪ್ಪಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ನಾನು ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ನಾವು ಒಪ್ಪಿಗೆ ಅವರು The order that you had challenged was an order passed on your consent. So you.
They have mentioned. They have mentioned. I am not given any consent.
Therefore, should you not have mentioned in the appeal that you had never given consent?
But the order refer ಮಾಡಿದ್ದಾರೆ. That shows that I am not given any consent. I have protested that.
Where?
Filing before the Tahsildar. First instance, I have given a representation before the Tahsildar to cancel the.
Where is that? Where is that?
That order copy is not produced. But it is referred in the same order. It is in 70, page number 70. ಫಸ್ಟ್ ಕಾಲದಲ್ಲಿ ಆ ಡೇಟ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ತಹಸೀಲ್ದಾರ್ ಮಂಡ್ಯ ಅವರಿಗೆ ಆದೇಶದಿಂದ ದಿನಾಂಕ 28/12 ಡಿಗ್ರಿ ವಹಿಸಲಾಗಿದೆ. And that order I challenged before the assistant commissioner.
ಇಲ್ಲ ಇದಲ್ಲ ಬರೀ ಇದು ಟು ಇಶ್ಯೂ ನೋಟಿಸ್ಗೆ ಈ ಸಂಬಂಧ ಮೇಲ್ಮನವಿದಾರರು ಹಾಗೂ ಎದುರುದಾರನ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗುವಂತೆ ಹಾಗೂ ಕಡತ ಇದೆಯಾ ಲೆಟರ್ ಇದೆಯಾ?
My number submission the already final decree was gone and the allotment of share was allotted 1/5 share and the parties before the honorable court, the petitioner and the respondent concerned, they have approached the civil court and obtained this final decree on the standard. There is a order is there. And as per that, the partition was affected by the civil court. The decree is.
ಇವಾಗ ಹಾಕಿರೋ OS ನಂಬರ್ ಎಷ್ಟು?
ಈಗ ಹಾಕಿರೋ OS number it is 247/2021. Recently I have filed. After filing the revision petition before the. I am sorry. The appeal pending ಇದ್ದಾಗ I am challenging the gift one, not regard to sale deed ಆಗಲಿ ಅದ್ರ ಬಗ್ಗೆ ನಾನು.
So you concede the sale.
ಅಲ್ಲ ಕನ್ಸಿಡ್ ಅಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ನನಗೆ ನಾಲೆಜ್ ಇಲ್ಲ. I am not taken any. ಯಾಕಂದ್ರೆ I have not mentioned anything in the rate petition.
No. In the suit, have you sought for gift is in respect of the property which was not sold?
Gift, what will happen, Your Honor? Gift, she taken the advantage of Tata.
Correct.
She gifted property to her daughter.
Gift is in respect of the property which was not sold by the three of you. You have no objection for the sale that you have done. I will.
Submission before the filing the entire petition, they are not mentioned the sale deeds. They are not mentioned that they have not taken any contention. You have sold the property to so and so.
Not said so in petition. Aren't you guilty of suppressing material facts? Aren't you guilty of suppressing material facts? Is it not a material fact that you have sold this property? Not. I'll dismiss the writ petition only on that ground. Forget about him. You get over this issue. Then I will dismiss it only on that ground. But you are guilty of suppressing material fact. I'll impose cost on you. How can you, after selling the land along with them, not mention that in the writ petition? You are challenging the order of mutation. The subject matter of the mutation has already been sought by the three of you. Should you not mention it there? Then I'll dismiss it only on that ground. No, you cannot take us for granted, isn't it? Then no, I'm not blaming you personally. I'm saying talking about your client. Why should we entertain a petition from a petitioner who has suppressed this fact? Suppose I had allowed the writ petition, then the mutation would have stand restored to your name, notwithstanding the sale. No, I thought you had mentioned in the writ petition. When I dismiss it with costs, whatever will happen will happen. What do you mean? How can the party not say this to the lawyer? Nah, you have done a good thing, but your client should suffer for the wrong that he has done. Aha. Madam, ಇಷ್ಟು ವ್ಯಾಜ್ಯ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಇದು ಗೊತ್ತಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನ್ ಮೇಡಮ್? Even before the AC, none of you appeared. No, your parties do not appear and oppose. So you are taking everybody for granted. Then, all right, before the DC, did you tell the DC that we already sold? The three of us have sold? I'll take your advice. How much cost should I impose?
They have already suffered this because of this, and it should be like the advocate who came afterwards.
I'm not blaming the advocate at all. Advocate would not know whether the party has sold. Whatever the party says, he will act upon that. How can you blame the advocate for this? Is it your case that you informed the lawyer and yet the lawyer did not incorporate this? I will not permit to say that now.
When I made an inquiry in the party, they told me they have already sold the party. That is the reason I said not to say. That is the submission in the morning I made also. And
when you submitted, I assumed that it was there in the pleadings. Fastest advocate, sir.
Now, I can keep the parties present.
I don't need the parties.
I keep the parties in present.
You obtain a decree, ignore the decree, get a kata of your convenience, depending on the consent. Then you sell the property. You don't inform the authorities about the sale. You don't inform this court about the sale in your pleadings. So you assume that you are above everything. The decree that you obtain is of no consequence to you. The sale that you did is of no consequence to you. You don't seem to be under an obligation to inform any of the authorities about the sale. ಎಷ್ಟು ಎಕರೆ ಜಮೀನಿದೆ ಒಟ್ಟು? ನೀವೇ ಅದಕ್ಕೆ ಐಲ್ ಟೇಕ್ ಯುವರ್ ಅಡ್ವೈಸ್. ಎಷ್ಟು ಕಾಸ್ಟ್ ಆಗ್ತದೆ ಅಷ್ಟೇ ಆಗ್ತದೆ. The petitioner, the counsel for the petitioner, these facts are not disputed. Then it comes to the petitioner. Next one. The one or ನಿಮ್ಮ ತಂದೆ ಹೆಸರು? The petitioner, first petitioner, Ratnamma, is the daughter of Basvalingayala. Where? Yes.
The petitioner wanted to have been two decades after date of oral participation and the first petitioner both responded.
ಹೇಳಿದಾರಲ್ರಿ? ಇಲ್ಲ ಅವರು ಹೇಳಿದಾರಲ್ಲ. Have jointly sold the respective one. They have mentioned it. ಇಲ್ಲ ಬಟ್ ಏನೋ ಮಾರಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದಾರಲ್ಲ. Krishna Ratnamma is the daughter of Basvalingappa. Basvalingappa had 5 children, namely Basvaya, Ratnamma, petitioner, Nagamma. Nagamma is the respondent. Okay. Nagamma, Gauramma, mother of respondents 5 and 6, and Shantamma, That respond number 4. Ratnama, Gauramma, and Shantamma instituted a suit for partition in OS 788/89 in respect of 5 items, 5 agricultural items, agricultural lands. The suit had been instituted against their brother Basvaya and another sister Nagamma, who was initially a plaintiff but was later transposed as second defendant. Close the bracket. Uncontested alva idu? The suit after contest, ended in a preliminary decree passed on 2nd of March 1999. ಮತ್ತೆ 99 ಅಂತ ಇದೆ preliminary decree. The preliminary decree on 11/11/1993. Where is that? Have you produced it? By the said decree, the plaintiffs, that is 3 sisters, were each granted 1/3 share. Appeal ಹಾಕಿದ್ದಾರೆ. Basvaya, the brother of the plaintiffs, preferred an appeal in RA 1/1994. This appeal was however dismissed on 23rd of January 2002. A second appeal was also preferred by him in RSA 327/2002, which was also dismissed on 10/12/2007. Thus, the decree granting each of the plaintiffs 1/5 share stood confirmed right up to this court. Next point. During the pendency of the regular appeal itself, the 3 sisters initiated final decree proceedings in FDP 28/1994. A final decree was also drawn up. Final decree was also drawn up on 2nd March 1999. You said 11/10/2001.
That was a sandpaper.
The degree was obtained on the sandpaper. On 23/8/2001.
However, despite the final decree, mutation proceedings were initiated in respect of ಯಾವ lands ಅದು? All the lands. In respect of ಜಾಸ್ತಿ ಇದೆ ಇಲ್ಲಿ. In respect of 8 items, including the agricultural lands which are a part of the decree. This mutation proceedings were initiated at the behest of the petitioner, and the passing of both the preliminary decree and the pendency of the final decree proceedings were not brought to the notice of the revenue authorities.
No, please, Your Honor. The RTC is entry of this.
When you sought for mutation, did you inform them that a final? Asking you, please understand the question. When you sought for mutation, did you seek for mutation on the basis of a preliminary decree or final decree? Where have you said so? Come to page 62. That is his whole argument, that you suppress the decree and please read page 62. When? MR?
OS number is seen. That is not part of the information. Or it is mentioned also.
That's correct. Learned counsel for the petitioner submits that pursuant to the preliminary decree itself, right, MR 18/96-97, the revenue entries in respect of the lands which is the subject matter of the writ petition were ordered to be mediated in favor of all the 5 children of Baswalingappa. Next paragraph. Learned counsel submits that thereafter, 2 of the sisters, that is Rasena, Gaurama and Shantam, agreed for the revenue entries to be mutated in favor of the petitioner herein, and by consent, the name of the petitioner was entered in the revenue records on 31/2 or 12, 31/12, 31/12 ಅಂತ ಇದಂಗೆ ಮೇಲ್ಗಡೆ on 31/12/2001. Next. Learned counsel for the petitioner also submits that pursuant to this order of mutation, all the 3 sisters jointly sold certain properties under 2 sale deeds dated and under 2 sale deeds both dated 18/1/2011. Learned counsel submits that since the sale deed has been executed by all the 3 sisters, it is obvious that none of the 3 sisters have any subsisting interest over the lands which are conveyed under these sale deeds. Learned counsel submits that thereafter, on 7/5/2011, Ratnamma, the petitioner, gifted the properties which had not been sold in favor of her daughter, the second petitioner, under registered sale deed dated 7/5/2011. So registered gift deed dated 7/5/2011 in favor of the second petitioner. And on the basis of this registered gift deed, the kata had been changed in favor of our daughter, the second petitioner. Next. It is submitted that thereafter, the petitioner's 2 sisters, that is Gauramma and Shantamma, Gauramma and Shantamma preferred an appeal. The LRs of, where is the order of the AC? Ibru hakadra appeal, obru hakadra. The legal heirs of Gauramma and Shantamma preferred an appeal, contending that the change of mutation, the change of entries in favor of Ratnamma in the year 2011, year 2001, was wholly illegal and contrary to the final decree that had been passed amongst themselves. Next, the Assistant Commissioner, however, dismissed the appeal on 2 grounds. Firstly, on the ground that there was inordinate delay in challenging the mutation made in favor of Ratnamma, and secondly, that there was a registered instrument in respect of the second petitioner, and therefore it was impermissible for the authorities to sit in judgment over the conveyance. Next, being aggrieved, the revision was preferred to the Deputy Commissioner. The Deputy Commissioner, by the impugned order, has come to the conclusion that the existence of a final decree granted by the Civil Court in FDP 28/94 was never brought to the notice of the revenue authorities, and the revenue entries were changed on the basis of consent of the two sisters, and this was impermissible. He has stated that the revenue authorities are bound by the decree of the civil code, and the revenue entries would therefore have to abide by the decree passed, final decree passed in the civil court in FDP 28/94, and is accordingly allowed the revision. It is as against this order the Deputy Commissioner, the present petition is filed. Learned Counsel for the petitioner contends that the Deputy Commissioner could not have set aside the order of the Assistant Commissioner, since the order passed by the Assistant Commissioner was a reasoned order. She submits that the Deputy Commissioner has not noticed the inordinate delay in filing of the appeal, and the Deputy Commissioner was wrong in directing the revenue entries to be made in accordance with the final decree proceedings in the light of a registered gift deed executed by the petitioner in favor of her daughter. She therefore submits that the order of the Deputy Commissioner cannot be sustained. Correct? Learned Counsel for the petitioner respondent, 4 on the other hand contends that the appeal was basically filed contending that the final decree which was between the petitioner, first petitioner, and her two sisters could not have been ignored, and the revenue entries could not have been made out in favor of the first petitioner alone. He submits that it is settled law that revenue entries would always be subject to the determination of rights by the civil courts. And once there's a determination of the right by the civil court, that cannot be bypassed either by consent and cannot be bypassed by consent. It is, as said above, it is the admitted case of the petitioner that she and her two sisters had instituted a suit and had obtained a preliminary decree on 11/11/1993. It is also the admitted case of the first petitioner that she and her two sisters also instituted final decree proceedings and obtained a final decree in FDP 28/1994. Under these decrees, under this final decree, the petitioner and her two sisters were held entitled to 1/5 share in the suitable properties. In the light of, it is also the admitted case of the first petitioner that the kata was indeed made out in the name of the three sisters as per the preliminary decree granted in OS 788/89. Next. In the light of these undisputed facts, the question that is to be considered and that was considered by the Deputy Commissioner was whether the order of mutation could have been made on the basis of consent contrary to the final decree proceedings. Next part. The Assistant Commissioner has taken the view that the appeal was belated and there is also a registered gift deed executed by the first petitioner in favor of the second petitioner, and therefore the appeal could not be entertained. The Deputy Commissioner, however, in revision, has taken the view that in the ultimate analysis, the revenue entries should reflect the determination of rights by the civil court, and if there was any mutation made contrary to the determination of rights by the civil court, the same cannot be sustained. In my view, this reasoning of the Deputy Commissioner cannot be found fault with, especially when it is the admitted case of the first petitioner herself that there is a decree granted by the civil court once a decree has been granted by the civil court, comma, neither the first petitioner nor our sisters can wish away the said preliminary decree and demand the revenue authorities to mutate the names in the revenue records to suit their convenience. Even if such mutation is made, comma, since it would be contrary to the decree passed by the trial court, comma, the same cannot be sustained. The Deputy Commissioner was therefore absolutely justified in allowing the revision and directing the revenue records to be made out in accordance with the final decree proceedings. Next part. It is over admitted both by the learned counsel of the petitioner as well as by the counsel for respondents 4 to 6 that all three sisters have together sold it is admitted by the counsel for the petitioner that the first petitioner along with the two sisters have sold certain agricultural lands which were a part of the suit schedule in favor of third parties under a registered sale deed. In the light of this admission that the first petitioner sold certain lands along with the two sisters, comma, obviously these properties, which are the subject matter of the two sale deeds dated 18/1/2011, cannot be mutated in accordance with the final decree because the decree holders have conveyed the properties jointly under a registered instrument. Next part. In respect of the properties which are not sold, comma, the revenue authorities would be obliged to enter the revenue records in as per the final decree proceedings. Next part. The argument of the learned counsel for the petitioner that there is a registered gift deed in favor of the second defendant, second petitioner, and this would have to be given effect to, cannot be accepted. It is to be stated here that if the revenue entries are to be mutated in favor of the second petitioner's mother in accordance with the decree, comma, the second petitioner cannot seek for mutation of the revenue records in excess of what her mother owned or possessed in the lands in question. The second petitioner's contention, therefore, that the final decree proceedings will have to be ignored and only the registered gift deed will have to be acted upon, cannot be accepted. It is also brought to my notice that respondents 3 to 6 have already instituted 4 to 6 have already instituted OS 247/2021, challenging the execution of gift deed by the first petitioner in favor of the second petitioner. It is needless to state that in the event the said suit is decreed in favor of the it is needless to state that in the event the civil court upholds the gift in favor of the second petitioner and dismisses the suit of respondents 4 to 6, obviously the revenue entries would then have to abide by the said decree. Subject to the above, the writ petition is dismissed. ನಾನೇನು ಏನು ಹೇಳಿದ್ ಬರೀ ಡಿಗ್ರಿ ಪ್ರಕಾರ ಮಾಡೋದಿದೆ. You will have to take the consequences of it. It will probably be decreed. That was my intent also. Okay. I have said it in context of the revenue proceedings. If your mother could have only 1/5 share, there should be a consequence. ಏನಕ್ಕೆ ತರಿಸಿದ್ದು ಇದು? Wait. ಯಾರು ಬರ್ತಾರೆ? ಫಸ್ಟ್ ಯಾರು ಬರಲಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಆನ್ಸರ್. Last chance ಕೊಡೋಣ. There is no appearance on behalf of the petitioner. So Learned Counsel, Learned AGS submits that the Sagolichit register has been secured and it indicates that no Sagolichit had been issued in favor of the petitioner. And the Sagolichit issued in favor of the father of the petitioner is a fabricated document. Relist on next witness.
Number 28.
Next Wednesday. Next Wednesday finally.
Number 56. Order matter.
Do that. Shankar.
Number 56.
N.A. Shankar. Friday. Friday, finish it. If you give them too much time, they'll start thinking too much. Both your client and these clients are very smart. The smartest is what has created this problem. So Friday, let's Zoom ಇದೆ WhatsApp call ಇದೆ Friday. Remote extent.
My lord, I
Yes, Prakash.
Lord, I require one for 10 minutes. My lord, I have challenged, my lord.
Who's opposing you?
Pardon? No, nobody, my lord. Nobody.
What is the order that is challenged?
My lord, I have challenged, my lord, the order passed by the Karnataka Appellate Tribunal. My lord, it is a remand order, page 117. It is a remand order. Matter is remanded to the regional commissioner, now regional commissioner, then the divisional commissioner. My lord, the matter arises in this way, my lord, very simple matter. My lord, the three, I invite my lord's consideration to page 83, my lord. Page 83. That is typed copy of the order passed by the regional commissioner. That is, my lord, divisional, then divisional commissioner.
Oh, you challenge annexure T, no?
Allah, and I challenge, my lord, order passed by the Karnataka Appellate Tribunal. Page annexure T, page 117. My lord, therefore, I require, my lord, 5 minutes. My lord. I say what the background, so that, my lord, easy for my lord to decide. My lord, kindly take page 79, my lord. It is the order passed by the regional commissioner, which was set aside by the KAT. Come to, my lord, page 79, annexure M, my lord. Annexure M.
Yes.
Milord, this is the proceedings initiated by Regional Commissioner on the report of the Deputy Commissioner. Milord, kindly see there are 3 persons, Ganapaya, Kittayachar, Kempa alias Naga Naika. These are the 3 persons who are ex-appropriate rights of Sharavati hydro project were granted 2 acres of land, Milord, 2 acres of land each, Milord, in survey number, Milord, the old survey number, Milord, 116, they are renumbered as 15, 17 and 18, 3 persons. But what they did is, they immediately sold this land to Milord, this Ganapaya and Kittayachari by 2 sale deeds. Milord, they sold it to Milord, the fourth, the mother of Milord, respondent number 5, 6 and 7.
Ganapaya and Kittachari, na?
They, those 2, they have sold it. Then, Milord, this,
whom did they sell it to?
Milord, to the Srimatamma. Srimatamma.
Yavaga?
The third, Milord, Kempa alias Naga Naika.
When was the sale?
Milord, the sale was, Milord, 5/12/1967.
And the grant was?
Milord, grant was, Milord, 21/9/1967, Milord. Within 1 year, they sold it.
3367, page 79. 3367.
1967, 3, Milord, March 67.
Then,
Same year. Then, Milord, the third one, Kempa alias Naga Naika,
yes.
he also sold.
Yes.
But there is no sale deed. There is no registered sale deed forthcoming. Mutation was accepted, saying that by virtue of a sale.
Whom did he sell it to, Kempa?
Adu ade 67 alle.
Yarge?
Srimatammange. This has happened in 1967, all the 3.
There is no sale deed.
But there is no sale deed. But MR was accepted, mutation was accepted in MR number 6 of 1969-70. That was not challenged by anybody.
Yes.
This can you page 78 note, page 78.
I'll accept it next.
Yes. Well, what happened is, Milord, the first petitioner, Premelamma, and father of petitioner 2 and 3, Premelamma herself, and the father of Milord, petitioner 2 and 3, that is Rudrappa Gowda, he purchased this land, all the 6 acres from Srimatamma by way of 2 sale deeds. That is 9 to
Rudrappa Gowda.
Rudrappa Gowda. That is 9 to
2 sale deeds,
9 to 1989 and 10 to 1989.
Instead of 6 acres.
2 sale deeds I have produced. But what happened is, after the sale, mutation was accepted and he put in possession, he raised.
Joint purchase madra, Premelamma and Rudragowda. ಇಲ್ಲ ರುದ್ರಪ್ಪ ಗೌಡ ಅಂತ ತಗೊಂಡ ಪ್ರವೀಣ ತಗೊಂಡ್ರ.
My lord, it is my lord Rudrappa Gowda. I have produced sale deeds. Sale deeds I have produced as annexure A. My lord, it is by Rudrappa Gowda.
Not by Praveedamma.
Rudrappa Gowda is husband of first petitioner, father of petitioners 2 and 3.
So he purchased 6 acres and the 2 sale deeds.
Yes.
Then what happened?
Then what happened is, in 1991, and I'm sorry, 85-86, my lord.
Then 89.
ಹೌದು 85 ಅಲ್ಲೇ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನಿಷಿಯೇಟ್ ಆಗುತ್ತೆ on the ground that the original grantees having sold the land violated terms of the grant. Thereby, my lord, the grants were liable to be cancelled. A report was submitted by the deputy commissioner because
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದ್ದಾಗ ನೀವು ಕೊಂಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಹೌದು. Yes, ma'am.
ಏನಾಯ್ತು ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನಾಯ್ತು?
What that is page 79. What happens is the deputy commissioner he sends a report based on which proceedings were my lord initiated, and the regional commissioner notices that my lord your lordship is my lord, I have brought to your lordship notice sale was in the
Cancellation proceedings were dropped, huh?
yeah, yes, he drops the proceedings. Well, what is the contention of some of the original grantees was, is Srimatamma who purchased the land, he obtained their signature by misrepresentation, etc. Then regional commissioner said, if that is your contention, you have to approach civil court. I cannot decide the validity of the will. Anyway, since proceedings were initiated after 19 years, he thought it appropriate to drop it. This order of the deputy, the divisional commissioner dropping the proceedings start to be challenged by this seventh respondent in the writ petition by way of a writ petition in the year 2006. Page 97, your lordship, page 97.
R7 ಹೆಸರೇನು?
ಅದು ಅವರು not 97.
ಮಂಜಮ್ಮ.
ಮಂಜಮ್ಮ. But page 102, page 102.
WP
2320 of 2006.
2320
of 2006. So 91 order of the regional commissioner was
2321210 ಅಲ್ವಾ?
ಅಲ್ಲ 2320 ಮತ್ತೊಂದು ಇನ್ನೊಬ್ಬ ಮುರಳೀಧರ
ಪೇಜ್ ನಂಬರ್
ಇದು ಪೇಜ್ 102 ಮಂಜಮ್ಮಂದು ಇನ್ನೊಬ್ಬ ಇದು ಏನು ಸಿನ್ಸ್ the order of regional commissioner is appealable under my lord 49. This court said you go and prepare appeal. Court did not consider any of the contentions.
Was an appeal filed?
Because then my lord, the appeal was filed, my lord, Manjama, page 106. After dismissal of the writ petition, my lord, exercising the liberty, this appeal was filed. My lord, appeal was, my lord, that is 2006. The order is a connection team. Appeal number 822 of 2006. Now, my contention is this, my lord. Regional commissioner, my lord, regional commissioner has dropped the proceedings for forfeiture. What is that this lady wants? I don't understand, my lord. She can't be considered as an acute person. My lord, if the regional commissioner is an authority to, my lord, cancel.
What is the claim of hers over this land?
Pardon?
What is Manjamma claim over this land? What is her interest?
This lady, my lord, her husband was the grantee. Her husband, I have shown it, my lord, page 79. The three grantees. Kempa alias Naganaika. First is Ganpaya, Kittayachar. Last one is Kempa. Kempa is her husband.
So according to you, since the cancellation proceedings are dropped, she can have no grievance.
No grievance. But what happens is, suppose
ಈ ಗಣಪತಿ ಆಮೇಲೆ ಇನ್ನೊಬ್ರು ಕಿಟ್ಟಾಚಾರಿ ಅಂತ ಇದ್ರಲ್ಲ,
ಅವ್ರು ಏನು ಬರ್ಲಿಲ್ಲ,
ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿ? ಹೇಗೆ ಚಾಲೆಂಜ್ ಮಾಡಬಹುದು? They can't be, they can't have a grievance. What does the
KT say?
KT did not go into this aspect at all. KT says there is notice of ಅದೇನು ಹಾಜರು ಮಾಡಿಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ. This is nothing to show that they were served with a notice or not. The point number 2, my lord, page 124. My lord, instead, my lord, may I request, my lord, to go to page, my lord, 126, running page, because earlier they only state the facts. This tribunal verified the records and found that the land in question granted by the answer, but there is no reference in the grant certificate to the effect that land in question is granted to displaced holder. But there is reference to the effect sanctioned by Special Land Acquisition Officer, Vasanagar White. Thereby, the land in question might have been granted by the Tahsildar. Not all these things, why it is necessary? in order to find out whether she is a necessary party. What is that she wants by?
All right. No, for what? The cancellation of grant, proposed cancellation of grant was dropped. Therefore, the grant in favor of Kempa was upheld. How can she be aggrieved by this? Shana? The facts from the material, from the record, indicates that on 33/1967, an order of grant was made in favor of Ganapaya, Kitachari, Kempa, an extent of 2 acres each, in serve number 10 of Kalikapura, Kasaba Hobli, Wasnagar Taluk. Within about 9 months from the date of the grant, Ganapati and Kitachari conveyed the lands granted to them to Srimatama. It also appears that there was a sale by Kempa in respect of his granted land in favor of Srimatama, and a mutation order was also passed in MR 6/6970. Thus, from the revenue records, the revenue records indicates that Srimatama purchased an extent of 6 acres, which had been granted to Ganapaya, Kitachari, and Kempa. In the year 1985, proceedings were initiated by the divisional commissioner for cancellation of grant which had been made in favor of Ganapaya, Kitachari, Kempa, and also Srimatama. In the pendency of these cancellation proceedings, Srimatama under 2 sale deeds dated 9/12/89 and 9/2/89 and 10/2/89 conveyed the land that she had purchased to Rudrappa Gowda, the husband of the first petitioner and the father of petitioners 2 and 3. Ultimately, the divisional commissioner, by an order dated 4th of May 1991, dropped the proceedings for cancellation of the grant. Thus, the grant made in favor of Ganapaya, Kitachari, Kempa, and Kempa were not cancelled, and by virtue of the dropping of the proceedings, the grant was thereby affirmed. The 7th respondent herein, who stated to be the wife of Kempa, Manjamma, the 7th respondent herein, who claims to be the wife of Kempa, the grantee, over filed WP 2320/2006 before this court, and this court, by an order dated 5/7/2006, relegated Manjamma to the appellate remedy available under the Land Revenue Act. The 7th respondent Manjamma accordingly filed an appeal to the regional commissioner. Appellate remedy established. Manjamma invoked the liberty granted by this court and preferred an appeal to the Karnataka appellate tribunal. The appellate tribunal, as by the impugned order, set aside the order of the divisional commissioner and has remanded the matter to the divisional commissioner for fresh disposal in accordance with law. The learned counsel for the petitioner contends that the order of the tribunal cannot be sustained since Manjamma had absolutely no right to challenge the order passed by the divisional commissioner, essentially because the order was in her favor. So he contends that the land granted to Manjamma's husband has been affirmed by the impugned order, and therefore she could have had no grievance to prefer an appeal. In my view, the learned counsel is justified in making this submission. It is not in dispute that grants were made in favor of Ganapaya, Kittachari, and Kempa in the year 67. It is also not in dispute that proceedings to cancel these grants were initiated in 1985 by the divisional commissioner, and the divisional commissioner ultimately came to the conclusion that there was no justification for cancelling the grants and dropped the proceedings. Thus, the divisional commissioner basically affirmed the grant that had been made in favor of Manjamma's husband Kempa. In my view, since the order passed by the divisional commissioner was in favor of Kempa, that is the husband of Manjamma, she could not have obviously preferred an appeal to the tribunal. And the tribunal has committed a serious error in setting aside an order which was essentially in favor of the appellant, and therefore of the view that the order of the tribunal cannot be sustained, and the same is accordingly set aside.
Bless.
Number 5, Ramchandra.
Lord, in this matter, I beg to appear for respondent 5, C and D.
Next year. Order dated 31/3/89, and this petition is filed in 2000. ಅಲ್ಲ 89 order 2015 ಅಲ್ಲಿ ಸೆಂಡ್ ಮಾಡ್ತೀರಾ 2014 ಅಲ್ಲಿ. Read the order. Read. Read the order 31/3/89, page 31. First ಓದ್ಬಿಡಿ ಆರ್ಡರ್ ಅಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ ವಾಪಸ್
ಭೂಮಿಯನ್ನು ತಯಾರು ಮಾಡಿ ಕರೆತಂದು ಬಿಟ್ಟಿರ್ತಾರೆ. ಆನೆಯಲ್ಲಿ ಬರೆಯುವ ಅಕ್ಷರವನ್ನು ಯಾರು ತಮ್ಮ ಹಕ್ಕುಗಳಿಗೆ ಆಧಾರ ಮುಗಿಸಿ ಒಬ್ಬರಿಲ್ಲ. ಸರ್ಕಾರದಲ್ಲಿ ನಿರ್ಧಾರದ ದಾಖಲಾತಿ ಮತ್ತು ಹೇಳಿಕೆಗಳನ್ನು ತೋರಿಸಲಾಯಿತು. ಅರ್ಜಿದಾರ ಜವರಿಯವರು ಆನೇಕಲ್ ತಾಲೂಕು ಪಾನಿ ಹೋಗಿ ಮಂತ್ರಿಕ್ಕೆ ಸೇರಿದ ಸರಿ ನಂಬರ್ 150 ಮುಷ್ಟಿಗೆಯನ್ನು ಹಾಕಬೇಕು ಎಂದು ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಆದಿಭೋಗರಾಗಿ ಮುಂಬೈಸಲು ಮೈಸೂರು ನದಿಯ ಮತ್ತು ಧಾರ್ಮಿಕ ಏನಾದರೂ ಕೈಗೊಂಡು ದಿನಾಂಕ 9/8 ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. 7 ಜನರಿಗೆ ಕಾಲಮದೇವರ ಜಮೀನಾಗಿದ್ದು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಮನೆಯಲ್ಲಿ ಇನ್ನೂ ಅನೇಕ ಹೆಸರುಗಳಿಂದ ವಾರದ ಭೂಮಿಯನ್ನು ಅನುಭವಕ್ಕೆ ಮೋಸಡಿದಾರರು ಅಳತೆ ಮಾಡಿ ಆಕಾಶದೊಂದಿಗೆ ಪೆಟ್ಟುಗಳ ಅಳತೆಯಂತೆ ಅರ್ಜಿದಾರ ಸರಿ ನಂಬರ್ 150 ಎರಡು ಕಡೆ ಕಾಪಾಡಿ ಕಂಡು ಬರ್ತಾರೆ. ನಾವು ಉತ್ತರಕ್ಕೆ 0.32 ಗಂಟೆ ಎನ್ನುವಂತೆ ಕಾರ್ಯ ಸರಿ ಮತ್ತು ದಕ್ಷಿಣಕ್ಕೆ 2 ಎಕರೆ 20 ಗಂಟೆ 2 300 ವರ್ಷಗಳಿಂದ ಬಂದೇ ನಿಂತಿದೆ. ಅದಿದಾದ್ರೂ ಕಾಲ್ಮೆಟ್ ಮಾಡಿಕೊಂಡಾಗಿ ಆಕಾಶದಲ್ಲಿ ತೋರಿಸಿ ನಾನು ಆಗಿದೆ. ಅದೇ ರೀತಿ ಮಾಡಲು ಅಧಿಕಾರ ಪಡೆದಂತೆ ಕಾಣುವುದಿಲ್ಲ. ಸೂರ್ಯನಾರಾಯಣ ಪ್ರತಿ ಬದಿ ಎಸನಂತಿ 1974. Without issuing notice to contesting party, the criminal has passed into that.
What is your interest in this land?
We are the father of the citizen, and Suryanarayan is also one of the sons. Both of them are present application. And it should be one notice.
You are the sons of Ramchandraya. ನೀವೆಲ್ಲ ರಾಮಚಂದ್ರನ್ ಮಕ್ಕಳು. ನೀವೇನ್ ಅರ್ಜಿ ಹಾಕಿದ್ರಾ? ನಿಮ್ಮ ಅಪ್ಪ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಪ್ಪನ ಹೆಸರು ರಾಮಚಂದ್ರ. ವೇರ್ ಇಸ್ ಹಿಸ್ ಅಪ್ಲಿಕೇಶನ್? ಏನಿದು ತೀರ್ಮಾನ? What is this order? Where is your application? What is this ತೀರ್ಮಾನ ಅಂತ? ಏನ್ ತೀರ್ಮಾನ?
And the survey report report other report and evidence is recorded. So that's it. Sir, next email. Survey, ma'am, the report persons who are whose names are entered in the RTC are totally ignored.
No, by this order, annexure A, your claim was rejected in respect of
Other lands.
last 4 links in the ಮೇಲ್ಗಡೆ ಮಧ್ಯದ ಕೊನೆಯಲ್ಲಿ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರ ಸೂರ್ಯನಾರಾಯಣ ರಾವ್ ಅವರಿಗೆ ಮಂಟಪ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 150ರಲ್ಲಿ 1 ಎಕರೆ ಮತ್ತು 145ರಲ್ಲಿ ಪ್ರದೇಶಕ್ಕೆ ಆದಿಭೋಗದಾರನೆಂದು ತಿದ್ದುಪಡಿಯಾದ ಕರ್ನಾಟಕ ಧಾರ್ಮಿಕ ಸೋನ್ಸೋ ಅಂತೆ ನೋಂದಾಯಿಸಲು ಸರ್ವನಾಮದಿಂದ ತೀರ್ಮಾನಿಸಿರುತ್ತದೆ. ಸೊ 1 ಎಕರೆ ನಿಮಗೆ ಕೊಟ್ಟರು 150ರಲ್ಲಿ ಸುರೇಂದ್ರ ರಾವ್ ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಸರ್ವೆ ನಂಬರ್ 150ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅರ್ಜಿದಾರರ ಬೇಡಿಕೆಯನ್ನು ಅವರು ತಿದ್ದುಪಡಿಯಾದ ಕರ್ನಾಟಕ ಸೋನ್ಸೋ ಮತ್ತು ರೂಲ್ಸ್ ಸೋನ್ಸೋ ಅರ್ಹವಲ್ಲವೆಂದು ತಿರಸ್ಕರಿಸಿರುತ್ತದೆ. ಸೊ ನಿಮಗೇನು ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲಲ್ಲ, ಒನ್ಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್. ನೋ ದಿಸ್ ಇಸ್ ನಿಮ್ಮ ಆರ್ಡರ್ ಪ್ರಕಾರ ಇಬ್ರು ಇದಾರಲ್ಲ, ಸುರೇಂದ್ರ ರಾವ್ ರಾಮಚಂದ್ರಯ್ಯ. ಸೊ ನಿಮ್ಗೆ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ ಸುರೇಂದ್ರ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದು. ನಿಮ್ಗೆ ಅರ್ಜಿಯಲ್ಲಿ ನಿಮ್ಮ ಅರ್ಜಿ ವಜಾ ಮಾಡಿ ನಿಮ್ಗೆ ಕೊಡ್ದಿದ್ರೆ, ಇನ್ ವಾಟ್ ವೇರ್ ಯು ಅಗ್ರೀಡ್ ಬೈ ವಾಟ್ ಎವರ್ ಇಸ್ ಹ್ಯಾಪನ್ ಟು ದಟ್ ಲ್ಯಾಂಡ್, ಐ ವಿಲ್ ಚಾಲೆಂಜ್ ದಿಸ್ ಆರ್ಡರ್. Did you challenge this order? You were a party to this order, annexure A. Yes, your Ramchandra did not challenge this order. When? During his lifetime, he did not challenge. Then how can you challenge?
send an application. In fact, the application from prior to that,
Ramchand. What is the point in filing an application after the orders passed through the land tribunal? If your father did not correct, 150ಕ್ಕೆ ನಿಮ್ ತಂದೆ ಅರ್ಜಿ ಹಾಕಿದ್ರು. ಸೊ ಆ ಅರ್ಜಿ ವಜಾ ಆಯ್ತು. ಸೂರ್ಯರಾವ್ 1 ಎಕರೆ ಕೊಟ್ಟು ನಿಮ್ ಅರ್ಜಿ ನಿಮ್ಗೇನು ಕೊಡ್ಲಿಲ್ಲ. ನಾನು ಕೊಡ್ತಿರೋದು ತಪ್ಪು ಅಂತ ನೀವೇನು ಹೈಕೋರ್ಟ್ಗಾಗ್ಲಿ ಎಲ್ಲೂ ಬರ್ಲಿಲ್ಲ. ಅಂದ್ರೆ ರಾಮಚಂದ್ರಯ್ಯ ಬರ್ಲಿಲ್ಲ. ರಾಮಚಂದ್ರಯ್ಯ ಬರ್ದಿದ್ದಾಗ ಅವ್ರ ಹೆಂಡತಿ ಮಕ್ಳು ಹೆಂಗೆ ತಪ್ಪು ಆರ್ಡರ್ ಅಂತ ಬರಕಾಗತ್ತೆ 15 ವರ್ಷ ಆದ್ಮೇಲೆ? ನಿಮ್ಗೆ ಯಾಕೆ ಕೊಡ್ಬೇಕು? ನಿಮ್ ಅರ್ಜಿ ಹಾಕಿದ್ರು ವಜಾ ಮಾಡಿದ್ರು. ನೆಕ್ಸ್ಟ್ ಯಾರ ಅರ್ಜಿ ಇತ್ತು ಏನ್ ಕತೆನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ನಿಮ್ಗೇನ್ ಅಧಿಕಾರ ಇದೆ ಈ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ? ಅನೆಕ್ಷರ್ RTC ನಾನು ನೋಡಲ್ಲ. ನಾನು ಕೇಳ್ತಿರೋ ಪ್ರಶ್ನೆ ಉತ್ತರ ಫಸ್ಟ್ ಹೇಳ್ಬೇಕು. ನಿಮ್ಮ ಯಜಮಾನ್ರ ಹೆಸರಲ್ಲಿ ಇದೆ ಅರ್ಜಿ ವಜಾ ಕೊಡ್ಲಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ ನೀವ್ ಹೆಂಗ ಹಾಕ್ತೀರ ಅರ್ಜಿ? ನಿಮ್ ತಂದೆ ಅರ್ಜಿ ವಜಾ ಆದ್ಮೇಲೆ ನೀವು ಆ ಸ್ಟೂಡೆಂಟ್ ಮೇಲೆ ಪಾರ್ಟಿಷನ್ ದಾವ ಹಾಕೊಡಿ. ನೀವು ಹೊಸದಾಗ ಅರ್ಜಿ ಹಾಕೊಳಕ್ ಆಗಲ್ಲ. ಅವ್ರಿಗೆ ಸಮಾಧಾನ ಇತ್ತು, ಸ್ಟೂಡೆಂಟ್ರ 1 ಎಕರೆ ಸಾಕು ಅಂತ ಸುಮ್ನೆ ಇದ್ರು. ನೀವ್ಯಾರು ಬಂದು ಗಲಾಟೆ ಮಾಡಕ್ ಇಲ್ಲ ಇಲ್ಲ ಕಮ್ಮಿ ಆಯ್ತು ಅಂತ. ಅವ್ರು ಬದುಕಿದ್ರಲ್ಲ, ಬದುಕಿದಾಗ ಎಲ್ಲರೂ ಹೆಂಗ್ ಬರ್ತೀರಾ ನೀವು? ರಾಮಚಂದ್ರ ಏನು ಒಪ್ಕೊಂಡ್ರಲ್ಲ, ಸಾಕು ನಂಗೆ ಕೊಡ್ತಿರೋದು ಪರವಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. 82ನೇ ಇಸ್ವಿಲಿ ಆರ್ಡರ್ ಆಗಿದ್ದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಒಪ್ಕೊಂಡಂಗೆ ಅಲ್ವಾ ಸರ್? How can you make an application? What is the consequence of you making an application after your father's application rejected? And your father ನಿಮ್ಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಮ್ಗೂ ಮತ್ತೆ ಬಿಡಿ, ಯು ಎಂಜಾಯ್ ದಟ್ 1 acre ಅನ್ಕೊಂತ. ಯು ಕಾಂಟ್ ಚಾಲೆಂಜ್ ದ ನೆಕ್ಸ್ಟ್ ಸರ್ಬಿ. ಇದು ನಿಮ್ಗೆ 97 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು, ಅವ್ರು ಕೊಟ್ಟಿರೋದು 89 ಅಲ್ಲಿ. Next survey is 89. You are virtually inviting an order from me saying that annexure F is bad. 89 order is then ನಿಮ್ಗೆ ಯಾಕದು ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯೋ ಇಲ್ವೋ, ಯಾರಿಗೆ ಗ್ರೀವೆನ್ಸ್ ಅದಕ್ಕೆ? ನಿಮ್ಗೆ ಈ ಜಮೀನ್ ಮೇಲೆ ಹಕ್ಕು ಬಂದಿದ್ದು 97 ಅಲ್ಲಿ. Ramchandra avare, you could not have got this order in your favor. You could not have filed an application after your father's application was rejected. ಆಗಿದೆ 150 ಕೇಳಿದ್ರೆ ಅದು ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ, ಅದು ರಿಜೆಕ್ಷನ್. ಅದು ನಾನು ಏನ್ ಮಾಡ್ಲಿ? ನಿಮ್ ತಂದೆ ಒಪ್ಕೊಂಡ್ರಲ್ಲ ಆರ್ಡರ್ನ, ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ವಲ್ಲ. ಯಾವಾಗ ಅಂತ ನೀವು ಹೇಳಲಿಲ್ಲ. ನೀವು even if you had died, you cannot challenge that order. The fact that you made a second application. Then 82 ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದ್ದು? ಫಸ್ಟ್ ಆರ್ಡರ್ ನೆಕ್ಸ್ಟ್ ಸರಿ 82. For 4 years he did not challenge. ಏನಿಲ್ಲ ರಾಮಚಂದ್ರ ಅವರ. ಹೆಂಗೆ ಕೊಡೋದು ನಿಮ್ಗೆ? ನಿಮ್ ತಂದೆ ಅರ್ಜಿ ವಜಾ ಆಗಿತ್ತು, ನಿಮ್ ತಂದೆ ಒಪ್ಕೊಂಡ್ರೆ ಅದನ್ನ ಮತ್ತೊಂದ್ಸಲ ನೋಟಿಸ್ ಕೊಡೋದು ನಿಮ್ಗೆ? That is, besides, your father was a party to the order of year 82. He accepted this order. And you are coming after how many years? 15 years? When is the petition filed? When is the petition filed? 2014. After 15 years. Anything else? According to your synopsis, the petitioner and his deceased brother filed the application of grant in the year 1991. After an order had been passed in favor of the contesting respondents herein. ಏನಿಲ್ಲ ರಾಮಚಂದ್ರ ಅವರೇ, ಯಾರು ರೇಟ್ ಹಾಕಿದ್ರು? ಯಾರು ಇಡೀ ಸೂರ್ಯನಾರಾಯಣ ಕರ್ಕೊಂಡು ನಿಮ್ಗೆ ಏನಾಗಬೇಕು? ನಿಮ್ದು ಹೇಳಿ. ಏನಂತ? Friday.
That matter is urgent, Miller.
Friday, Babu.
Friday.
Manages to have the only influence the possible plan shows 20 situations. Both the AC as also as the DC reject my as also the ground that there are no documents to support the claim. It is my contention where reduced partitionally we are 1923 where the land is perfect or input to the control or conducting activities. Subsequently, the trust in the year 1961, it says that the trust has been formed in order to take care of the land. And this land belongs to the trust. Now, if I can just invite my lord's attention.
They are registered instruments?
Yes, sir.
1960.
Yes, sir. I can just invite my lord's attention to page 45.
So your basis is on the trust deed?
Yes, sir. Trust deed has also partition in the year 1993.
In favor, in your favor means in favor of the trust.
In favor, as I corrected in favor of the trust. If I can just invite my lord's attention to page 45.
Page
45. It's the genealogical view. This, my lord, is the genealogical view. Now, my lords, if I can just invite my lord's attention to 4 names specifically. My lords, in the first branch, my lords, there is a Gautabasa complex. Then number 2, there is a Chikabasa branch. Then number 3, my lords, in the third branch, below number 3, there is a Shanta complex. And in the 4th branch below, there is a Chikachana complex. These are the 4 legal names. Now, my lords, if I can just invite my lord's attention now to page number 24 months.
Yes.
Well, this is the trust. Well, this is the document which is created there in the year 1992. This is the partition. The four names that I mentioned are in the first paragraph.
Where is this? Where is the recital regarding this property? Where is the recital regarding the property in question?
Well, if I kindly have page number 28. Well, it's a third line onwards.
Give me a minute. 28.
Yes, sir. 28, the third line onwards.
Page 5, internal page 5. Internal page 5.
No, page 28.
Correct, but the document is internal page 5.
Yes, sir. Yes, sir. Third line onwards.
ನಾನು ಇಸೆಗಳನ್ನು Where is that? This first word is ರೂಪಾಯಿ ಜುಮ್ಲಾ 3005 100 ರೂಪಾಯಿನ ದೇಣಿ ಶಾಂತಪ್ಪನಾದ ನಾನು ಸೆಕೆಂಡ್ ಟೈಮ್
ಶೆಡ್ಯೂಲ್ 16, 17, 18 18 20, 22, 23, 24ನೇ ಸಂಖ್ಯೆ ಸ್ವತ್ತುಗಳು ಪೂರಾ ವೀರಭದ್ರ ಸ್ವಾಮಿ ದೇವರಿಗೆ 1120 ರೂಪಾಯಿ ಕಿಮ್ಮತ್ತಿಗೆ ಬಗ್ಗೆ
18 what else? So 16 17 18 20 and 23.
Yes, 16, 17, 18, 20, 22.
This is item numbers. This is item numbers.
Yes, sir. It's a schedule. What is the item numbers in the schedule? 19 is what we're concerned with. Item number 18. ಸಂಖ್ಯೆ ಸ್ವತ್ತುಗಳು ಕೂಡ ವೀರಭದ್ರ ಸ್ವಾಮಿ ದೇವರಿಗೆ 1120 ರೂಪಾಯಿ ಕಿಮ್ಮತ್ತಿನ ಬಗ್ಗೆ ಸಾಧಿರಾಯಿಸಿದ ಶೆಡ್ಯೂಲ್ 19ನೇ ಐಟಮ್ 7 so minus that goes into ವೀರಭದ್ರ ಸ್ವಾಮಿ ದೇವರಿಗೆ.
Okay.
Very good.
18, so item number 18 is where?
Yes,
page number?
Item number 18 is at page number 33. ಚಿಕ್ಕಬಳ್ಳಾಪುರದ ಕಸಬಾ ಶಿವಗಂಗೆ ಭಾಗದಲ್ಲಿ ಟೋಟಲ್ ಜಮೀನು 13 is the old survey number. We are
25 guntas.
Yes, 25 guntas. Now this same parcel of land we are 1923 is given to a temple matters for conducting temple activities. Now we are 1963 projects in India goes on the 16. There is a
60.
60.
Yes.
There is a trust which is created by us primarily because the temple has not been taken well care of by us. And this trust deed is basically created by the children of the four people who are part of the partnership deed. Now I just want to point out four things. Minutes, page number 62 minutes.
All right, I'll accept there's a trust deed. Then next what?
So these are the documents which say that this temple property belongs to the trust. Now, in the document here, whatever it is, so main fellows name is Mallikarjuna Chinnappa. It's 1920, the main owner of the property. His name continues with the RTC. In the year 2010, respondent number 5, who is one of the erstwhile trustees of this trust.
Under the 60 document.
Yes, sir.
Where is his name? Page number 60.
Well, page number 60, his father's name is M. Basappa. Page number 60, first.
Page number
60.
Well,
his father's name is
where?
The fifth line is M. Basappa. Well, if I can just bring my notes.
No, where? M. Basappa, no?
Yes, sir. M. Basappa. Page 45.
He is the father of the fifth respondent.
Yes, sir. Well, page 45, first branch. Below that there is Basappa.
Okay. On what basis did he get his name changed in the revenue records?
Well, what he claims is there is a Mallikarjuna Chinnappa. That is the main founder's name continues in the record. So he says I am related to it and therefore you change my name.
Where is that order of mutation in his favor?
Yes, sir. Well, it's a mutation order, also find it page 91. The tehsil as well.
From Mallikarjuna Channappa to MB Rajshekar.
Yes, sir.
Been on what basis?
Well, he just said someone the ignorant.
What was the basis for your?
He being the not son of the not the only owner of the property. The impression was taken.
You claim to be the son of Mallikarjuna Channappa.
No, the grandson. Grandson of Mallikarjuna.
So you are claiming M. Basappa was the son of Mallikarjuna
There no
Channappa.
other issues, not.
All right. The land was donated to the temple in the year 23.
That is an issue pending before the land was not clear in the file that is not. They are not narrated about the food.
So according to Mallikarjuna Channappa had only one son.
But he had several sons. There is no interstate.
Then how can you get it in your name
There is no
exclusively?
interstate dispute between the family members, not there any way.
On what basis, unless it's a registered instrument? How can the kata be made out only in the name of one son or rather one grandson?
But there is no claim not by any counter claim not or claim by the other family member.
Where's your application saying that there's no other claim and the others have consented?
There is no, not literally there was no not objection by the any of the family members. But giving a stranger to the not, I would take a minute.
Whether he's a stranger or not, there is a registered gift deed in favor of the deity. A trust. Okay, in a partition, it is granted to the temple. That also you don't dispute.
I dispute that.
If you dispute that, I will challenge that partition deed.
I am not at all not questioning the partition deed.
If there is a registered partition deed in which this property bearing number 13 is allotted to a temple without there being a challenge to it, how can you get the your name?
Corresponding not any entries not show that not the property is gifted to the deity except this partition deed.
It's a registered instrument.
He himself not filed the
It's a registered instrument.
They are not filed the registration. He seeks for a grant of that land.
I will not grant that prayer, don't worry.
Direction.
I will not grant that. I will say just set aside this order and all the corresponding orders of the Assistant Commission and Deputy Commissioner. Only on the ground that you had no basis in the light of this registered partition deed and the trust deed.
He has to make out not that he is one of the trustees. He is a trustee under the
Your father was one of the trustees in the 60 sale in the trust deed.
But this property was never.
If your father was a trustee under the 60 deed, how can you claim to have succeeded to this property from your grandfather?
But the revenue is since inception must stand in the name of my grandfather, not Mallikarjuna Channappa. Never they have been affected in the name of any of the as claimed by them.
You go to the civil court and establish your rights regarding succession from Mallikarjuna Channappa.
These one lots the deed is withdrawn, but the property lots is not standing in the trust. The lordship of kindness is not.
But there are registered instruments.
He himself leads not in the description of 17. But that the property standing in the name of Mallikarjuna Channappa.
Correct. That is wrong. In the light of the registered instrument, I will direct the authorities to act as per the registered instrument.
The registered instrument has never been acted upon.
Now it will be acted upon. And once it is a registered instrument, there is no obligation for them to inform the authorities. The authorities are bound to get the mutation made.
Lordship of kindly lots to take one paragraph which is relying on the trustee. But wherein it is clearly stated that the family have to be trustees. Now,
You enjoy being a trustee. Whoever is a trustee, your father was a trustee, continue to be a trustee. But if the trustee, then if you are the only surviving legal heir, under the trust act, do whatever you want to do to become a trustee. So long as there is a trustee, I will direct the authorities to maintain the revenue records in the name of the trust.
Lordship of kindly is claim number 51. The trustee will be relying on. The clause reads, each trustee
Yes.
each trustee can only last paragraph.
11 ಜನಕ್ಕೆ
ಈ ಟ್ರಸ್ಟಿಗೆ ಹೊಂದಿದ್ದು ಜನಕ್ಕೆ
11 ಜನಕ್ಕೆ
ಜನಕ್ಕೆ ಹೆಚ್ಚಿಗೆ ಇಲ್ಲದೆವು 5 ಕಮ್ಮಿ ಇಲ್ಲದೆವು ಟ್ರಸ್ಟ್ಗಳು ಇರತಕ್ಕದ್ದು. ಈ ಟ್ರಸ್ಟ್ ಅನ್ನು ನಮ್ಮ ವಂಶಕರೇ ನಡೆಸಿಕೊಂಡು ಹೋಗಲು ಯಾವಾಗಲೂ ನಮ್ಮ ವಂಶಕರೇ 7 ಜನ ಟ್ರಸ್ಟಿಗಳಾಗಿರ್ತಕ್ಕದ್ದು. ಉಳಿದ 4 ಜನ ಇತರ ಟ್ರಸ್ಟ್ಗಳನ್ನಾಗಿ ನೇಮಿಸುತ್ತಾರೆ.
Correct. Therefore, even by your own conduct, your father agreed that there should be a trust which should be confined only to the family members. All the trust should be family members.
Now the petitioner
We will ignore him. I will direct the authorities by virtue of your statement to have the records in the name of the trust. Whatever is a trust, whether the trust exists or does not exist. If you claim that you are the only sole surviving trustee, go under the Trust Act and do whatever you want to do.
I'm not claiming that I'm a trustee here. I'm claiming not I being the only survivor.
Once you admit the trustee, there's no question of you succeeding to the property. It is the property of the trust. How can you take that property of the trust?
Never been enrolled to the trust.
But your father is a. The trust deed refers to survey number 13.
He does not state even about.
Does the trust deed refer to survey number 13?
He finds us not and depending on
No, we'll come to this. We'll come to the suit afterwards. Does the trust deed stipulate that survey number 13 is a part of the trust property? Yes or no?
There is a reference to that.
That's it.
No, he himself has filed us not claiming that trust.
Living what?
On the trust claiming that trust, whether it's a trust or not, it's pending.
Until that trust deed is challenged and set aside, or that partition is challenged set aside, the property will have to be registered in the name of the temple and or the trust. I'll hold that the property should be registered in the name of the trust. Your father is a trustee, enjoy. You will become a trustee, but you cannot become the owner of the property in your individual name. Anyone? No, I will not. I believe that question either way. You can use that in the civil court, but as of now, I'm only concerned with the revenue entries. I will say all. I'm now setting aside that order. Why are you worried? Where is the order of the DC?
The order of the DC is at start with page 101.
ನಿಮ್ಮವರನ್ನು ಕೋಪ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ DC ಮುಂದೆ. This is the result of that tiff. ಅನವಶ್ಯಕವಾಗಿ ಕೋಪಗೊಂಡು ಸಭ್ಯವಾಗಿ ವರ್ತಿಸಿ. Who's the counsel? ಯಾರು ಲಾಯರ್? ಯಾರು ಶ್ರೀನಿವಾಸ್ ಇದು ಬರೆದಿರೋದು? ಅನವಶ್ಯವಾಗಿ ಕೋಪಗೊಂಡು ಅಸಭ್ಯವಾಗಿ ವರ್ತಿಸಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಅಗೌರವ ಉಂಟು ಮಾಡಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಿಚಾರಣೆ ಸಮಯದ ಪ್ರಕರಣವನ್ನು ವಜಾ ಮಾಡಲು ನಿರ್ಧರಿಸಲಾಯಿತು. He's been utterly frank about his feelings. Where is the order of mutation first that you showed? Next area F, right?
Yes.
In respect of land bearing survey number 13, Allah? No, next year F. What is the survey number? Land bearing survey number 7 of Shidlghata Bagilu, village Kasaba Hogli, Chikbalapur Talukan district. The revenue entries was standing in the name of one Mallikarjuna Channappa. Next, an application was made by the fifth respondent. By the fifth respondent, what is your name? MB Rajshekar, for change of mutation in his favor. This request was made ostensibly on the ground that MB Rajshekar was the grandson of the Katedar Mallikarjun Channappa. The said request was accepted and a mutation was ordered in favor of the fifth respondent by MR number 31/2011-12 by annexure F. Next part. The petitioner, who claims to be president of the trust to which server number 7 was donated, filed an appeal to the Assistant Commissioner. The Assistant Commissioner, however, rejected the appeal on the ground that the appellant had not established his entitlement to challenge the order of mutation. This order of the Assistant Commissioner has been confirmed in revision. Learned counsel for the petitioner submits that under registered partition deed dated December, what is the date? 6th December, date Akilala, 6th December 1923. 6 properties, including survey number 13. Partition registered deed of partition. The registered deed of partition dated 6th December 1923. 6 items were donated in favor of Veerabhadra Swami Temple. And survey number 13, practically item number 18 in the partition deed, was also one of the said properties. It is submitted that subsequently survey number 13 has been renumbered as survey number 7. It is also submitted to the land council of the petitioner that the members of the family who had donated the said land had also formed a trust under registered deed of trust dated 28/8/1964, and to this trust, the father of the fifth respondent, namely M. Basappa, was also a trustee. He submits that survey number. He submits that the trustee to which the father of the petitioner was a party indicates that survey number 7, bracket old number 7, was the property of the trust. He submits in the light of the registered partition deed and the registered trust deed. The authorities had no jurisdiction to come to the conclusion that the petitioner, which is the trust, had no entitlement to challenge the mutation in favor of the fifth respondent. Next, learned counsel for the fifth respondent, on the other hand, contended that the order of mutation in favor of fifth respondent could not be found fault with, since he was the only sole surviving legal heir of Mallikarjuna Channappa. It is not in dispute. And the learned counsel of fifth respondent does not dispute the fact that there was a registered partition of the year 1923, and that thereafter, on 28/8/1964, a trust was formed in which his own father Basappa was a trustee. And this trust deed indicated that survey number 13, old number 7 was trust property. In the light of the fact that the fifth respondent does not dispute the creation of the trust on 28/8/64, to which his father was also a trustee, it is obvious that the fifth respondent could not have sought for change of mutation in his individual name. So in other words, when it is not in dispute that survey number 13 was a trust property, the fifth respondent could not have staked a claim to have his name mutated in the revenue records. Next paragraph. In my view, since there are registered instruments of partition of the year 23, indicating the survey number 7, bracketed new number 13, was being allotted in favor of the temple, and there's also a registered trust deed dated 28/8/64, indicating that survey number 13 was trust property, the Assistant Commissioner and the Deputy Commissioner had seriously erred in coming to the conclusion that the petitioner had no jurisdiction, no entitlement to challenge the order of mutation. I therefore set aside the order of mutation, bracketed MR 31/2011-12, and its affirmation by the Assistant Commissioner and also the Deputy Commissioner. In the light of the registered partition deed and the registered trust deed dated 28/8/64, it would be necessary for the revenue authorities to mutate the name of the petitioner, the name of Sri Mallikarjuna Channappanavara Charitable Trust, Chikbalapur, in the revenue records in relation to survey number 13. Writ petition is accordingly allowed. Next part. It is also informed to me that a suit has been filed in OS number
13.
Then what is that for? Then what is this OS 180/2009? Next D that you have produced. He is also a party to the suit.
This earlier OS has been produced only to show that respondent number 5 is a trustee. Nothing else. That was in respect to some other property matters.
It may also be pertinent to state here that the petitioner trust had instituted OS 180/2009 for recovery of rents and eviction against one Velu Swami. The costed, the judgment passed in OS 180/2009 is produced in Annexure D. The costed of the said judgment indicates that the fifth respondent, M.B. Rajshekar, is in fact the fifth plaintiff in the suit and is described as a trustee of the Mallikarjuna Chinnappa Charities Trust. This fact also confirms the fact that there is a trust to which the fifth respondent himself was a trustee. In the light of this document, it would not be open for the fifth respondent to claim any exclusive right in respect of survey number 13. There is a You did not dispute that. Have you disputed that in the objections? It is supposed to come in your way. You can't be a trustee in the suit and then claim that you are not aware of the trust. That is only a suit for injunction. Have you filed any rejoinder saying that the trustee produced or objections? In this writ petition, you dispute the fact that there is the registered trustee. You dispute the execution of the trust deed.
I have disputed about the first exception to my statement of this.
Let us see. You are a fifth plaintiff in the suit. How can you say that there is no trust?
He has made me a party to suit, but I am not at all.
You are a plaintiff.
I have not signed a wakalat. He made all the proceedings.
Show me in your objections.
Number one.
Para number?
One. The outfit, the present petition is not mentioned on the ground. Has no local.
Your
local signed challenge.
the objections filed on 5/4/21.
Yes.
First paragraph is present petition is filed.
4 lines below. At the outset, the present petition is not mentioned on the ground that the petition has no local standing. Challenge the same as he stated in the land. After the lead seeking for direction, land of civil land, this is uncalled for and impounded. Since the said land survey at no point of the land granted to either the parties nor it is the case of the petition that subject land is granted. Likewise, in present private petition regarding the challenge in case of with respondent and not a grant, not a grant.
Where do you talk about the trust deed? You are silent about the trust deed.
For the petition is stranger and making false state of the land person without there being any right title or interest for the subject land. He is trying to create complicated documents in order to legally claim the subject land that belonging to trust. That's why the present expression as well as the appeal, the revision.
Where have you said that there was no trust deed and your father was not a party to the trust deed?
Denied not that there was a complicated document not regarding.
Is that, can this be considered as a denial of the execution of the trust deed?
I've said the very document is a fabricated document.
You should say that the trust deed that is produced is a fabricated document. Your father is not a trustee.
About the trust in this petition, I've said that has been a fabricated document.
If you want, I'll give you liberty to file a suit and establish your rights.
Even that liberty may be not welcome.
It is open for the petitioner, for the fifth respondent, to approach the civil court seeking for an appropriate declaratory decree in respect of the lands in question. And in the event the petitioner, fifth respondent, obtains a decree, obviously, the revenue entries would have to abide by the said decree.
Admission, even if you have a bearing on my life, how could I make an admission when we are denied?
Admit and admittedly, the trustee dated so and so indicates. Wherever it is said, I'll say server number 13, bracket hold server number 7. Okay. Server number 7, hold number 13.
Number 8,
ಏನಕ್ಕೆ ಏನ್ ಮಾಡಿ ನಮ್ಮ ಸರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರಾ The petition is filed seeking for a direction to the respondent to regularize the unauthorized cultivation of land bearing number 131, measuring 1 acre 20 guntas, situate at Kallavadi village, Jaipur Hubli, Bangalore Taluk, as requested by the petitioner. His application dated 28/1991. Next paragraph. The petitioner contends that he has made an application on 10/10/1988 Right, annexure A. In the said application, it is stated that the petitioner was in unauthorized occupation. Of certain lands, and the same was required to be regularized in his favor. Petitioner has also produced an acknowledgement for having submitted an application for regularization in respect of serial number 131, measuring 2 acres as per annexure B. In my view, in the light of this averment, it will be necessary to direct the respondent to consider the application, third respondent, to consider the application, if any, that has been filed by the petitioner as stated in the writ petition. If such an application has in fact been filed, the third respondent shall consider the same and pass appropriate orders within a period of 3 months from the date of receipt of a copy of this order.
When you go on the result of the application, what is can be shown? Or which action
Until the consideration of the petitioner's application, the petitioner shall not be dispossessed. If, however, it is found that the petitioner had not submitted the application as contained in the writ petition, steps may be taken to dispose of the petitioner in accordance with law after notifying him. Next, A. Tenant or landlord? When was the first order?
First order is 23.
24/10/79.
It is not under
That is the first order.
first order.
Under the first order, so many serial numbers were granted.
So many numbers were granted. And that has been filed.
Okay. Now, what do you want modification?
No. He filed the modification.
You are for the landlord of the tenant.
I am the landlord.
Okay. What did you seek for modification?
85(3), it should be 85(2). And we see the order is annexed
No, page 26. No, the first order. The mention is only about 85/3B and 85/5C. Instead of
85/40 cents.
there is no 85/B at all. Granted to you. 3B ಇದೆ. 85/5C ಮಾತ್ರ.
In the 80, that is 85/2.
But where is your form number 7? It's not there in form number 7.
It is not in form number 7, but in the order
Yes. Yes. ಇಲ್ಲ 85/5B ಕೊಟ್ಟೇ ಇಲ್ವಲ್ಲ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ. ದಿ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇಸ್ ಅರ್ಜಿದಾರರು ಕರ್ನಾಟಕ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 85/5B ರಲ್ಲಿ 40 ಸೆಂಟ್ಸ್ ಹಾಗೂ ಇನ್ನಿತರ ಸರ್ವೆ ನಂಬರ್ಗಳ ಜಾಗಗಳಿಗೆ ಈ ಹಿಂದಿನ ಭೂಮಿ ಮಂಡಳಿಗೆ ನಮೂನೆ 7ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಅದೇ 85 where is your application for amendment?
And the NDCT is.
No, if he's not heard in the matter, send it back. Let him be heard.
Survey number 85/5B
I did not see 85 but 12 also in the order.
Application,
Huh? Like 85 but 12 will be alvana. Your either prakara. So number 85 ಬರ ಎಂಬುದರ ಬದಲು 85/5B ಎಂದು ತಪ್ಪಾಗಿ ನಮೂದಿಸಿರುತ್ತಾರೆ. 85/5B ನೂ ಇಲ್ಲ ಅಲ್ಲಿ. 5B, no, the finding is by mistake instead of 85/12, 85/5B is given. The order does not even indicate that 85/5B is granted. No, how can I go for the gain receipt? The order is no, since he says there's no notice, I'll send it back, let him reconsider it. Let him also object there only. Why should we go into this question here?
Portion of it is already acquired. That acquisition proceeds is at page 32.
The compensation will remain. That is all.
At least there is a daily chief.
No, but you cannot modify the order of land tribunal now on the basis of the gain check. Let them reconsider. I'll make it clear that they will refer the order and check with reference to the form number 7. That is all. An order was passed by the land tribunal. Keep it with you till it is decided. Suppose you decide that he is not entitled, then you don't have to pay the money to anybody. Who's stopping you from taking possession? If you acquired it, then take possession. Deposit the money into court and take possession. An order was passed to the land tribunal on 24/10/79, conferring several items of agricultural land in favor of Sidhu Pujari. This order, conferring occupants' rights, has attained finality in as much as the landlords have not challenged any reputation, have not filed any reputation. We need to make the application date idea. When was the order passed? Nearly after 20 years, an application has been made by the legal heirs of Sidhu Pujari, seeking for modification of the order dated 24/10/79. The land tribunal has accepted the application and has stated that Sidhu Pujari should be construed as a tenant in respect of 85/12B and modified its earlier order accordingly. Then counsel for the petitioners. Petitioners. ಎಲ್ಲಿ
RTC ಪಡಿಸಿ ಭೂಮಾಲಕರು ಕೂಡ ಈ ಜಾಗವು ಬೇಡಿಕೆ ಒಳಪಟ್ಟಿರುವುದಾಗಿ ಒಪ್ಪಿ ಬೇಡಿಕೆ ನೀಡಿರುತ್ತಾರೆ. And kindly see the Geni chip. R1 6190/65 is the Geni chip.
ಅದರ ಭೂಮಾಲಕರು ಕೂಡ ಈ ಜಾಗ ಗೇಣಿ ಒಳಪಟ್ಟಿರುವುದಾಗಿ ಒಪ್ಪಿಕೊಂಡಿರುವುದಾಗಿ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಗೇಣಿ ಚೀಟಿಯಲ್ಲಿ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಗೇಣಿ ಚೀಟಿ ಕೋರ್ಟ್ ಮುಂದೆ ಅಲ್ಲ, ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ ಅಲ್ಲ.
And election includes this line.
The it is not very clear from the order of the land tribunal as to whether this order of modification was made after hearing the landlords. So in fact, Union Counsel for the petitioners strenuously contends that the petitioners were not notified about these proposed amendment proceedings, about the proceedings to amend the order of the land tribunal. In such a situation, in my view, it would be appropriate to set aside the order of the land tribunal and remit the matter to the land tribunal to reconsider the application for amendment after affording an opportunity of hearing to the landlords, that is the petitioners hearing, and also the LRs of the tenant. Next point. It is made clear that the land tribunal shall consider the application for modification after considering the lands claimed in the form number 7 and the lands that had been granted by it on 24/10/79 and examine whether the order dated 24/10/79 could be modified or was justified for modification, or there is justification for modification of the said order. So all contentions of either parties regarding the modification are left open to be decided by the tribunal. Next part. It is also informed that a portion of this land, which is subject matter of the modification, has been acquired by the National Highway Authority. Yes, respondent. Which respondent? That is the third respondent. That comes to the third respondent submits that the compensation amount is yet to be dispersed. The third respondent is therefore directed to deposit the compensation amount before the civil court, and the civil court shall pass appropriate orders after the land tribunal passes appropriate orders on the application for modification. But if not already deposited, the compensation amount, if not deposited, shall be deposited with the civil court and will await the order, and the same will be dispersed in accordance with the orders passed by the land tribunal. I said, that's why I said it is not clear on that. Annexure.
Directly, to continue the entries.
Your request for entering the bond is rejected. No, this is by the Tahsildar. If he refuses to mutate the entry in your favor. Correct. Let us assume you made an application for restoration. If that is rejected, should we go to the Assistant Commissioner? For what? So you don't want to challenge Annexure A? You have sought for quashing of Annexure K. So long as Annexure K stands, I can't issue that mandamus. If you are challenging Annexure K, your remedy is by way of an appeal. You're making me to do the job of the assistant commissioner.
But how the authorities are harassing farmers? But annexure code, like 88. It was very small. But the Tahsildar, very same Tahsildar rights to the assistant commissioner.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಇದರಲ್ಲಿ ಹೋಗಿ ಇಷ್ಟರ ಗ್ರಾಮ ಸರ್ವನಗರ ರತ್ನಾಕರದಲ್ಲಿ 10 acres ಜಮೀನನ್ನು ಬರದ ಪಣಿ ಅಂತೆ ಗಣಿಕೃತ ಪಣಿ ತಿದ್ದುಪಡಿ ವಿಚಾರದಲ್ಲಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಈ ಕಚೇರಿಯಿಂದ ದಿನಾಂಕ 4/4 ತಮಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಈ ಬಗ್ಗೆ ಪ್ರಸ್ತುತ ಜಮೀನಿನ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಫಾರ್ ರೆಕಾರ್ಡ್ ಈ ಬಗ್ಗೆ ಪ್ರಸ್ತುತ ಜಮೀನಿನ ಮೂಲ ಮಂಜೂರಾತಿ ಕಳತ ಪತ್ತೆ ಹಚ್ಚಿ ಮಂಜೂರಾತಿ ಜಮೀನಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ಕೃತಿಯನ್ನು ಕಟ್ಟಿ ಸಂದಾಯ ಮಾಡಿದ ಬಗ್ಗೆ ದೃಢೀಕೃತ ದಾಖಲೆ ಪಡೆದು ದಾಖಲೆಗಳ ನೈಜತೆ ದೃಢೀಕರಿಸಿ ದೃಢೀಕೃತ ಪಹಣಿಯಲ್ಲಿ ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ದಾಖಲೆ ತಂದಿರುವುದೆಂಬ ಮಾಹಿತಿಯನ್ನು ಹಾಗೂ ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ಅಳತೆ ಕಾಲದಲ್ಲಿ ಈ ಜಮೀನುಗಳನ್ನು ಹೇಗೆ ಪರಿಗಣಿಸಲಾಗಿದೆ ಎಂಬುದರ ಬಗ್ಗೆ ಮಾಹಿತಿಯನ್ನು ಮೂಲ ಮಂಜೂರಾತಿ ಕಳತದೊಂದಿಗೆ ಸಲ್ಲಿಸುವಂತೆ ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ಮೂಲ ಮಂಜೂರಾತಿ ಕಳತದಲ್ಲಿರುವ ಸಾಗುವಳಿ ಚೀಟಿ ಮತ್ತು ಮಂಜೂರಾತಿ ಜಮೀನಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ಕೃತಿಯನ್ನು ಸಂದಾಯ ಮಾಡಿದ ಬಗ್ಗೆ ಟ್ರೆಜರಿಯಿಂದ ಚಲನ್ ಪಡೆದು ದೃಢೀಕರಿಸಿ ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಇಪ್ಪತ್ತರ ಗ್ರಾಮ ಸರ್ವನಗರ 14 10 ಎಕರೆ ಜಮೀನು HM ಪಟ್ಟಾಭಿರಾಮಯ್ಯ 52-53ರಲ್ಲಿ ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾತಿಯಾಗಿ ನಂತರ ಪೂರ್ತ ಜಮೀನು ಶ್ರೀ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ನಂಜಪ್ಪ ಇವರಿಗೆ 66-67ರಲ್ಲಿ ಕ್ರಯಪತ್ರ ಮಾಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಹಾಗೂ ಕ್ರಯಪತ್ರದಂತೆ MR ನಂಬರ್ 16 ಖಾತೆಯಾಗಿ 1968-69 2001-2002ರವರೆಗೆ ಕೈಬರಹದ ಪಣಿಯಲ್ಲಿ ನಮೂದಿರುತ್ತದೆ. 2001-2ರ ಪಣಿಯಂತೆ ಕೃಷ್ಣಪ್ಪನವರ ಮಕ್ಕಳ ಹೆಸರಿಗೆ ಖಾತೆ ಸಹ ಆಗಿದೆ. ಈ ಹಿಂದೆ 2001ರಲ್ಲಿ ಕೈಬರಹದ ಪಣಿಗಳಂತೆ ಗಣಕ ಪಣಿಗೆ ಡಾಟಾ ಎಂಟ್ರಿ ಮಾಡುವಾಗ ಕೈ ಬಿಟ್ಟಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ಅಳತೆ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಜಮೀನನ್ನು ವರದಿದಾರರು ಒತ್ತುವರಿ ಮಾಡಿರುವುದಾಗಿ
From 1966-67, if his name is found up to 2001 and 2002, and if it is admitted by the Tahsildar that it was omitted while computerization. Order ಮಾಡಲ ಏನು ಮಾಡಿ appeal ಬೇಡ ನಂಗೆ because I am last paragraph you say ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ಅಳತೆ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರು ಒತ್ತುವರಿ ಮಾಡಿರುವುದಾಗಿ ಸ್ಕೆಚ್ ನಲ್ಲಿ ತೋರಿಸುವಂತೆ ಒತ್ತುವರಿ ಪಟ್ಟಿಯಲ್ಲಿ ಇರುತ್ತದೆ. You will not stop at this. Restore ಮಾಡಿರೋ ತಿರ್ಗಾ you will start this. Have you filed any affidavit? Then get the Tahsildar. Not counsel for learned AGA seeks time to secure instructions regarding the communication dated 9/3/2011 addressed by the Tahsildar to the Assistant Commissioner, in which the Tahsildar confirms the fact that there was a grant in favor of the petitioner's vendor, and thereafter the revenue entries were continued in the name of the father of the petitioners right from 68 to 69 till 2001/2002, and with the computerization of the RTCs, the name of the commissioner of the petitioners had been omitted. Released on next Wednesday. File an affidavit of his or else 2 weeks, 2014. Rest I'll repeat next week. Yeah. ನೋಡಿದ್ದೀರಾ?
Consider election the father of the petitioner was in position, and it was found that the election here also was inspection report was produced as election date. And even in 1884 election, he also he was in position. And as per election day application, form number 50 was filed at page 30.
consider annexure Q ashte then. The prayer in the petition is to direct the respondent. Direct the Tahsildar Bangalore North Taluk to consider the representation dated 23/4/2021, which is produced as annexure Q to the writ petition. In annexure Q, the petitioner contends that land bearing cell number 178, bracket and old number 159, has been ಏನಾಗಿದೆ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು ಅಂತೀರ ನೀವು?
Out of 10 persons, these 2 persons refer. As for election seat was granted to others, adjacent land has been granted in same land. Election seat.
ನಿಮ್ಗೆ ಪ್ರೇಯರೇ ಇಲ್ಲ, ಏನು ಅಂತ ಪ್ರೇಯರ್ ಇಲ್ಲ. ನೀವ್ ಹೇಳ್ತಿರೋದು ಏನಿಲ್ಲ ಶ್ರೀನಿವಾಸ್ ಇಲ್ಲ. It is stated that the petitioner and his family members have been in possession of the property since 1972. It is also stated that similarly placed persons such as T.S. Bhagiratham have been granted the said land, and the petitioner being on the same footing is entitled to the same privilege. In view of the fact that the petitioner is making certain claims in his representation dated 23/4/2021 on parity with similarly placed persons, it will be necessary to direct the Tahsildar to consider the claim of the petitioner in accordance with law within a period of 3 months from the date of receipt of a copy of this order. Seal number? DVR ke? ಇದರಲ್ಲ ಹೆಸರಿದೆಯಲ್ಲ, ನೀವು ವಕಾಲತ್ ಹಾಕಿದಾರಾ? ಹೌದು ಸರ್.